direction to the opposite party to settle the one-time settlement application which is pending with them. They have kept the upfront amount of rupees 25 lakh 29,000. This is referred in page 33 and 34, Your Lordship.
So you appear for the bank?
I am.
Lordship, no, I am for the
application.
Your Lordship, I have instruction to appear. I have not received the read.
No, it's all right. Application. He seeks an order to pass an order on the application. Therefore, there is an application. Take a call on that.
Your Lordship may take it after a week.
No, not for that. How you are agreed? Even in absence, we would have made that order.
Your Lordship, I have no instruction.
All right, we'll say that. We'll say that. We'll protect you also. Short grievance of the petitioner borrower is as to long pendency of his OTS application made to the rest. OP Bank, which bank?
the bank, HDFC Bank, Your Lordship.
OP HDFC Bank. First off, counsel for the petitioner submits that a sum of rupees 25 lakh
29,000.
29,000 is remitted along with the application to facilitate its favorable consideration in terms of extant RBI guidelines. And therefore, the bank is bound to take a decision on the application, this side or that side, not keeping it indefinitely. First off, he submits that this duty is public duty arises in view of Apex Court decision in Gujarat State Finance Corporation versus Lotus Group of Hotels. Sorry. Next paragraph. Learned panel counsel, Miss, what's your name, daughter?
Your Lordship, B. Pooja.
Miss Pooja, B. Pooja.
On behalf of
Srimati Pooja?
Nalini On behalf of Nalini Kantadas.
Appearing on behalf of panel counsel Shri so and so for the OP Bank seeks some accommodation, saying that instructions are to be received from the client, and thereafter the counter needs to be filed. First off, we do not agree with this proposal in as much as the petitioner's prayer is innocuous. First time, it is for an order to pass an order on the OTS application. First time. Next paragraph, outcome application, keeping open all contentions of the parties. First time. In the above circumstances, petition is disposed of, directing the OP Bank to take a call on the subject application preferably within an outer limit of 8 weeks. First up, in that connection, all contentions of the parties are kept open. First up, it hardly needs to be stated that the decision has to be made in keeping in view the extant RBI guidelines operating in the realm. No cause.
Item 2, WPC 7538 of 2026.
The petitioner, bank is the petitioner in this writ petition.
Make use of the mic.
My lord, bank is the petitioner in this writ petition. My lord, here, the bank is aggrieved in the order passed by the DRT Kolkata, wherein the DRT Kolkata at page 22,
10,000 rupees cost is
cost for addition, for adding the party as an auction purchaser. But the facts remains, my lord, in the surpass application, the loaning, though ever of, as per the objection.
Take notice. Take. That's your emergent notice. Returnable within 4 weeks. Within what period that amount to be remitted?
My lord, 10,000, my lord. My lord, that time yesterday matter was before the DRT person Kolkata, but a matter was adjourned that was not uploaded.
Pendente nite, the impugned order levying 10,000 rupees cost is kept in suspended derivation. Okay. Have you made any application
My lord, in
for
that,
stay of the order?
yes, I have heard.
IAT is pulled on. Okay. Huh.
My lord, the stay of operation of that order because stay of operation of
Yeah, obligation. Yes. If we may not use the same English word, English is a rich language.
we are learning from the lord.
No, I'm also learning from. Yes.
Item 3, WPC 9151 of 2026.
My lord, in this matter, I am the petitioner is the Loni, my lord. Loni and
You are changing your roles. Once as a lawyer for the Loni,
my
and
lord,
next for the lender.
occasionally in few cases. My lord, here, my lord, the collector.
We said it in 2 months.
Lord, here,
Whichever brief comes to you, have to argue.
my lord, here the collector has passed that order,
14 order.
13 order,
Huh.
without verifying the 9 clauses as incorporated in the section
That
14.
apex code decision.
That is the apex code decision.
What
Here,
is the amount due?
my lord, amount due is 73 lakhs. I am ready to pay rupees 10 lakhs. But the legality and the propriety and the correctness
That's all
of
right.
the order to be decided.
Question is not that. Question is, this is writ jurisdiction, 227 jurisdiction.
My lord, sir.
Therefore,
But still then, in PSR, Info Bank versus
we have seen that
judgment,
judgment.
that the lordship say under Article 223 power has not been
Not 226, 227.
My lord, my respectful submission before the lordship.
You pay 25% of the amount. That we have made it.
Yes, your lordship.
We have made it 30%. 30%. You cannot change from person to person. They will doubt us.
My lord,
We'll give easy
in-
installments. Some installments. Challenge in this petition is to the coercive action of recovery. First one. The order made by the district collector,
my lord,
collector under section 14 of the Surface Act 2002 is called in question. Inter alia pressing into service the decision of the apex court in Lupo Bank versus
Eco Bank versus PSR inventor.
right now. Sorry. Next, the counsel for the petitioner vehemently argues that unless the 9-point affidavit is put into consideration, order of the kind would not have been. First, an arguable case is made out for issuance of emergent notice and also grant of reprieve, of course, subject to conditions. In the above circumstances, issue emergent notice to the OPs. First off, interim order as sought for till next date of hearing, subject to petitioner paying to the loan account 30% of the amount outstanding, yes, in 3 weekly installments. 3 equalized weekly installments. Filling which not only the reprieve stands rescinded, but petition itself runs the risk of call of proceedings.
My lord, that amount due as indicated in the possession notice, that is the amount is 73 lakhs.
Which
73 lakhs in 2024.
My lord,
So, we will say-
because under surface,
26, 2 years. What is the rate of interest?
12%.
12. Even if it is 12 into 12, 144. Another 14 lakhs will be there, na?
Yes, lordship. Instead of 30% with percent, 25%.
We can't change the
Yes.
yardsticks depending upon who
Oblige, deep oblige.
Item 4, Rate Appeal 3243 of 2024.
2 weeks back, your lordship had this matter and passed order. Everything is same, I have corrected.
Identical.
Well, identical, only case number, read petition number is to be given.
So, Behura.
And even copy, your lordship. My lord. Only one line is to be corrected.
Ah.
I have, in the pencil, I have corrected.
You have corrected that.
My lord.
Thank you so much.
Modified, not corrected.
Sorry, my lord.
Item 5, Rate Appeal 433 of 2025.
My lords,
What have
here,
you done in this matter?
my lords, here, in fact, the instruction is that the Chief Minister Relief Fund has negatived his claim.
Mr. G, you appeared thrice in this matter.
I had also got that instruction.
My lords,
That 80,000 rupees.
yes, my lord,
So show that is very negative.
because he has not it was not accompanied with bills and other things. On that ground, my lords,
No, on what ground you are negative?
my lords,
Minister cannot act as a Mughal.
no.
He is under the law.
My lords,
They are not fulfilling the criteria.
my lords, kindly see this instruction, para 3, my lords.
Where is that policy? Where is that policy?
Your lordship will file counter, it will be better, my lords. My lords, it is not,
We gave
it is,
time
my lords,
only for that purpose.
kindly see the last para. Currently, my lords, as per the order of this honorable court, in earlier writ petition, a committee is looking after once the report will come, it will be considered again, my lords. Not that any malafide and
You file objection.
no.
If you file counter, because
My lord,
two things they are saying. Number one, the hospital where your client's husband was treated, maybe for cancer,
yes,
is not an empaneled hospital.
yes,
Because policy requires, which I have mentioned here, just share a copy of this with your
my
friend.
lord, I have already submitted both the answers.
Is it?
Yes, my
It's an empaneled hospital.
no, my lord.
Therefore, they're
Yes,
saying unless the policy says,
Yes, my lord. That Annex 21 of the writ petition has been challenged.
you
In the
file counter,
original.
we are calling
My lord,
call this matter week of.
My lord,
No, it requires consideration because once we grant relief to you, others may form a queue in front of the court. Therefore, and financial implication is involved. We understand the difficulty of your client also. Wait, week after next. Okay. So next.
Item 6, Writ Appeal 1656 of 2025. Item 6, Writ Appeal.
OPSP. Password. Password, let us see. I think.
6 is mine.
Call after 2 weeks, the Honorable Counsel for the appellant to come and argue.
My lord, item 6, my lord.
Public Service Commission.
no, my lord.
No, it is different, my lord. It's a case of challenging writ appeal, my lord. Challenging the order passed by the learned single judge. The state has preferred this appeal before your lordships. The honorable court, my lord, has directed at page 66, your lordship may kindly have a look. Further, while allowing the writ petition, this court directs the opposite parties to regularize the service of the petitioners in the post of the sweeper as against the available vacancy in such post. In the event no such posts are available, this court further directs that supernumerary post be created and regularize the service of the petitioner to accommodate the petitioner, and such creation of the post shall continue till the petitioners retire from service. Let the aforesaid direction be carried out within a period of 3 months from the date of communication of the today's
This is
judgment.
in terms of Sitaram Behara's case.
Yes, Sitaram Mehra's case as well as
So nothing in appeal.
they are, my lord, also taken care of the judgment of Jago's case. Jago and Shripad.
Umadevi, Jago, all judgments
All the
are care of here, na?
My lord, I am also referring, my lord, to a judgment of Bholanath. There, lordship have said that in the direction portion, my lord, paragraph 5, can I place that, my lord?
5.5.
In view of the foregoing discussions, we direct the respondent state to forthwith regularize the services of the appellants against sanctioned posts
Correct.
to which they were initially appointed. The appellants shall be entitled to all consequential service benefits accruing from the date of this judgment. My lord,
We have held following that in that electricity matter. Who
yes,
appeared, I don't remember. Mr. Lenka appeared in that. We have held. Create supernumerary posts and posts will wither away with the retirement of these people.
my lord, the problem here, my lord, this appointment was not made against any sanctioned force.
Therefore, question arises, creating the post. That question arises.
Yes,
Only when there is no sanction. How that is going to help
that
you?
post, regular posts were
How many
abolished.
years of service he has put in? 2020. Yes, everything is considered, brother. He has put in 20 years of service. That's fine. Any delay is there?
Yes,
How many days delay?
63 days
Another
only.
ground for us.
Only 63 days.
63 days. What is the explanation? How explanation is offered?
It is a stereotype.
Right. Now change your record. At least the format has to be changed. No? State government and its officials have preferred this intra-court writ appeal for laying a challenge to a learned single judge's order judgment dated 14/7/2025, whereby may be seated respondent employees writ petition C number 9324 of 2024 having in favor a direction in substance has been issued for their regularization in service, comma, by creating a supernumerary force if need be. First term. Next paragraph. Having heard learned counsel for the appellants and having perused the appeal papers, we decline indulgence in the matter for the following reasons. A. Learned single judge at para 15 of the impugned judgment has specifically stated about the credentials of the one respondent. How many?
One. No, my lord.
Multiple.
Multiple.
Of the respondent who admittedly have been uninterruptedly serving the state as daily wages since 2005.
Right.
First one. Learned judge has specifically stated that this factual position is not controverted by the appellant hearing before him. First one. Therefore, there is no reason to doubt the version here. First one. Next point. One more thing. It is not the case of the appellants that there is any complaint or the like against the respondent's hearing. Therefore, a strong presumption arises that their services are satisfactory and the requirement is subsisting. First, next paragraph. Learned single judge has referred to the entire jurisprudence relating to law of regularization, beginning from Uma Devi to Jago, and also the latest decision in 26. Last paragraph, including Sitaram Behra's case. Just looking to all this one. First one. It hardly needs to be stated that it is insufficient to point out that the impugned order is wrong. First off, what is required for interference in appellate jurisdiction is something more, namely unsustainability of the impugned order. which has not been demonstrated despite passionate submission made by the learned GA. First off, next paragraph. In the above circumstance, next one more. Above apart, there is a delay of 68 days in preferring the 63 days in preferring the intra-court appeal. First off, although an application supported by affidavit in IA number so and so accompanies the appeal memo, the explanation offered appears to be ritualistic to say the least. First off, unless the explanation is plausible, delay cannot be condoned mechanically. First off, next paragraph. In the above circumstances, the appeal is rejected both on delay and on merits. With a direction to the appellants to give effect to the impugned order of the learned single judge within an outer limit of 8 weeks, failing which they run the risk of contempt action.
Lordship,
Yeah.
like this will your lordship was like this Bholamnath case, my lord. Their lordship said that the appellant shall be entitled to all consequential service benefits accruing from the date of this judgment. Will that?
Nothing. We are not interfering. Next.
Item 7, WPC 5753 of 2006.
Item 7, my lord. I am filing my bhaklampta with Suraj Mahathi. May I take it for tomorrow, my lord?
Not tomorrow. We'll have it brother, any urgency?
Yes, my lord. What is the urgency? The man is 70, 80 years. For that reason, I am praying for tomorrow only.
Because we have also no counter copies, etc.
I will supply the everything. I will supply.
We'll have it, we'll fix a date. 22nd of
My lord.
April.
My lord. I will supply the counter. They have
In the meanwhile, you
Nothing is there.
block all his contentions. Very old matter.
Very good. That's why I am praying for tomorrow. Anyway, because records are not with him, I will supply him all the records, what he wants.
No, you give him so that we will have breathing time to go through.
Yes, my lord. I will give him the records that before my lords, with the records which are before.
Complete records.
Yes, so that.
On 22nd, we'll have that.
My lord.
Let him turn the pages.
My lord.
Talk.
Item 8, WPC 27313 of 2017.
One man is.
Lordship,
Yes, sir.
pardon for my late appearance.
Yes, sir. Yes.
So, Lordship, I want to give the mental memo. Actually, on 12th Feb, the Honorable Court has given the order of issuing emergency notice, and it has been also been issued, and the interval benefit has not been given.
Not given to you.
Yeah. So,
How many years of service you have put in, sir?
sir, 10 years it has been retirement. So,
You retired in the year?
and before 10, 15 years, like 12 something.
Mr. G.
My lord, which item you are?
Okay, where about that?
Listing for listing is.
Listing.
I wanted for-
Darling. When do you want?
On 10th, Your Lordship.
10th.
This is a single.
We cannot sit on Friday. Huh.
On 9th also.
Huh?
On 9th April is also.
Day after.
Yeah.
You are coming from which place?
I am coming from Bhubaneswar, but my senior will be appearing.
Your senior will be appearing. All right. Can we have it on 22nd?
Your Lordship. Okay.
Yeah. 22nd. All right. You did not notice it.
It's okay, sir. That I was late for appearing.
No problem. No problem. Sometimes we also will be late, na? Yeah.
Thank
Next.
Item 8, WPC 27313 of 2017.
Last occasion, October directed take inspection whether the petitioner is continuing or not.
Yeah. Is he continuing?
Yes, I get the certificate from the concerned authority.
What is the matter?
After my lordship only, I pray that lordship may see my compilation of documents I have submitted, my lord. The entire documents I have given compilation of the documents. It will be easier to. Still is continuing since 2007.
What is the case about?
Case for regularization. My juniors have been regularized.
When you entered service, sir?
I've entered in 7 to 1996.
7 to 96.
96.
Whether any selection process happened or just entry, backdoor entry?
And no.
As?
And the other two juniors
No, sorry. As what?
as class 4 employee. Daily wages.
Daily wages.
Daily wages.
Daily.
Another 2 persons with me also.
Class 4 is D group in your state. D, group D.
But the judgment, my lord, it speaks, my lord. Judgment passed by the tribunal.
Two juniors. Those who have appointed my
Who are
me,
Who are they?
who are the opposite party 3 and 4. Though notice was issued, short, but they did not appear, my lord.
OP is 3 and 4.
3 and 4.
They are juniors 3.
They are juniors.
They are appointed on which day?
15 to 96.
And
And 13 to 96.
they are regularized.
They have been regularized
With
19.
which order?
My lord. This is there. Many compensation, page 5 and 6. I've given a read application, but your lordship may see my compensation document
Whether pursuant to court order they have been regularized or on their own?
on their own. They have been regularized during the 1999, man.
Same day.
Same day, 8 and 9.
2 to 99.
2 to 99. Thereafter, I have been not allowed to work. I approached the Honorable Tribunal, my lord. Tribunal disposed of the way that you consider the matter. My representation was rejected. Again, that order, I prefer again the original application before the tribunal. After hearing
That application number?
first application or second application? My lord?
First application.
First application is OA number 1869. 1869 by 99. Disposed upon 27/1/2000. Is only the
Direction to consider your representation.
in view of the pendency of the representation, no final order can be passed at this stage. In this case, the chief district medical officer Nayagad is directed to consider and pass appropriate order.
Order.
That
All
order
right.
was passed.
That's a standard format. Order. Well, that came to be rejected.
Rejected.
Your representation was rejected when?
Rejected on 22/8/2005.
Why you rejected?
Rejected that on the ground that because as per the present government policy, that is 2005 policy, my whoever disposal on 2000, they are rejected as per the present government policy. All vacant regular posts of class 4 group D are to be abolished and replaced by an equal member of daily wages post. On that ground only they were rejected. Again that order, again I prefer a original application.
That OA is?
Who is 974 by 2005.
974.
By 2005.
Rejected on?
Disposed upon.
Disposed of.
Disposed of.
Again disposed of.
Again disposed.
28/10/2005.
28/10/2005.
Saying?
28/10/2005.
It is regularized with effect of the date without, of course, the benefit of drawing regular salary, but notionally, so that it could be adjusted against an existing vacancy now.
There the Honorable Tribunal hold that I remit back the case to the first respondent to verify the reference to the record available in the office of the CDMO as to whether the applicant was actually senior to the 3 persons, those who are regularized, and if the applicant was indeed senior to those 3 persons on the date they were regularized, then yes, he should consider why the applicant cannot be regularized with effect from that date, without, of course, the benefit of drawing regular salary, but notionally, so that he could adjust it against the existing vacancy post. That order was passed. that if age is here, then regularize. There, page 16.
So it's rejected.
No, not rejected, man.
Yes. When they come to page 31.
Yes? Ah, yes.
31.
Yes. Then that order was also confirmed by the Honorable High Court.
Which order?
This order, where the tribunal has directed to consider whether I am indeed senior or not.
Seven. Order number 3535 of 2013.
What happened to 974 of 2005?
974, that order has challenged by the state before the Honorable Court.
What happened?
They have again rejected.
Rejected on?
Rejected on 16/4/13. On the ground that
Then what happened to that order? It was carried to High Court.
that order, that again I prefer to original application before the tribunal.
Thereafter,
The tribunal has rejected the,
again.
That is annexure 7, Your Lordship was read.
OA number?
that is way number.
3535 of 2013.
Annexure 7. To the imperial.
No, once it was rejected, how is that you applied the tribunal again?
Sorry, my lord.
Your OA 974 of 2005 was rejected on 16/4/2013.
That is
No, that's not.
by the,
No, you were not able to place it properly. 974 of 2005
my lord,
was disposed of on 28th of October 2005 itself,
my lord.
wherein the tribunal directed the authority to look into the fact whether your juniors have been appointed.
Oh, my lord.
If they have been appointed, then your case is also to be considered.
My lord. This is the,
Against that, the state went on
No, before the
challenging
Honorable
before this court.
my lord. It was dismissed.
It was dismissed,
My lord.
but the department did not consider your
Consider.
case in view of 974.
My lord.
That is how again you came to
Okay.
it.
Therefore, I have just. That WP is what?
WPC filed by the state, my lord. 9335.
Huh?
9335 WPC was filed by the state against the order passed in 974, my lord,
9335
of 2007.
that was dismissed on?
That was dismissed on 2/12/2009. So 974 order was confirmed. In spite of that, they again rejected.
They rejected.
They again rejected. Considering the order of the 974 order, what they rejected.
That rejection happened on which day?
16/4/2013.
So that you challenged in OA 3535 of 2013. That again is rejected.
Though tribunal taken all the into consideration, but rejected on the ground that negativity cannot claim negativity. Only that.
Negative equality.
Mr. G,
My lord.
in order in OA 974 of 2005, there was a there was an adverse order against you.
My lord.
If two juniors are appointed, the inner voice of that order was,
Why
if
not?
two of his juniors are appointed,
Why not
then he should be regularized.
regularized?
That you had challenged and failed.
My lord.
That operates as res judicata. The apex court in the party versus party 62-63, which is that judgment. The constitutional bench of the apex court said the doctrine of res judicata operates in successive stages of the proceedings.
My lord.
So, if you have suffered that order, your WP 9335/2007 being dismissed on 2/12/2009, how could the tribunal reject his claim?
My lord, he is challenging that rejection order passed by the department.
Correct.
My lord.
That itself we are asking you. Though department will do things mechanically, that is another thing.
My lord.
But tribunal cannot be that mechanical.
My lord, tribunal has also dealt with that, dealt with the issue.
It said the regularization order was not legal. How can that be?
My lord, they have
The
said-
regularization of two of, I read that.
Yeah.
We read
Paragraph
it very
30.
fastly, I read. The two of the junior tribunal says a faulty reason because you had taken up the contention. They were wrongly regularized.
wrongly regularized.
Therefore, from a wrong, right does not take a birth is your contention. Though it's not
Yes.
that beautifully you have put it.
Yes.
That way you have said. Where is the wrong? You have power to regularize. And you did not deregularize them. When you take up the contention,
Well-
no, we did it wrongly, but we have rectified it. That is not your case. And power to regularize is enormous with the employer, unless the rules say it should be only the according normative basis.
Obliged, my lord.
During that period, where was the norm? The norm was only daily, Dharwad daily wages case. 1990 Supreme Court. 881.
Your Lordship, at paragraph 5 of the impugned order, have said that the fact remains that the respondent number 3 and 4 were junior to the applicant, but their services have been regularized.
Wrongly.
But it is-
You have said they are wrongly.
And he did not rectify, they continued. He will suffer, being senior to them.
Yeah,
Right of the order passed by the tribunal.
tribunal affirmed by the division bench.
Ma'am.
No, we are allowing this. Right. A daily wager is invoking writ jurisdiction of this court for laying a challenge to the state administrative tribunal's order dated 16/4/2013. No. Huh? 3535.
Where to think?
Huh.
1/3/2017.
20 February 2017, whereby his claim for regularization made in OA 3535 of 2013 has been negatived. First, kindly be seated, both of you. Learned counsel for the petitioner. Next. After service of notice, the official respondents are represented, have entered appearance through the learned agent who vehemently opposes the petition, essentially contending that the claim was made by the petitioner herein on the principle of parity, two of his juniors having been regularized in by the order dated 2/2099, and that the said regularization itself was defective, and therefore there is no scope for invoking the principle of parity. First off, he tells us that a wrong order cannot deliver a right in favor of another on the principle of parity. First off. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant indulgence in the matter for the following reasons. A. Petitioner admittedly came to be engaged as a daily wager with the effect from 7/2/1996 in Group D, along with, first of Group D. Respondent numbers 3 and 4 herein were also engaged on the daily wager basis, respectively with effect from 15/2/1996 and 13/3/1996. Kindly rectify,
Yes.
just when if there is any IPC. First off, this fact is not in dispute. First off, petitioners OA 1869 of 1999 came to be disposed of by the tribunal by order dated 27/1/2000, directing consideration of his case, keeping in view the parity principle for respondent numbers 3 and 4 herein, who have remained absent despite service of notice. First off. Next paragraph. The claim of the petitioner was again rejected and rejected wide order dated 22/8/2005, and therefore he filed OA 974 of 2005, wherein the tribunal wide order dated 16/4/2013, 28/10 28/10/2005, 28/10/2005,
22 I sat these.
22/8/2005, 22/8/2005. Then there is some that order, tribunal's order is what? 974 of 2004.
Well,
Order is dated?
order dated 28/10/2005.
that is what I said.
28/10/2005 had directed consideration of petitioner's claim for regularization on the ground that the other juniors were already regularized, as mentioned above. First off, this was put in challenge by the respondent state in WP 9335 of 2007, and the same came to be dismissed by a coordinate bench. Coordinate bench or single judge? Coordinate bench. Wide order dated 2/12/2009. First. Therefore, the fact that two of petitioner's juniors were regularized, and as a consequence, case of the petitioner has to be considered on parity basis, remains intact, having received imprimatur at the hands of coordinate bench. First of all, that being the position, we fail to understand how the government could reject claim of the petitioner wide order dated 16/4/2013, and we are awestruck by the fact that the tribunal too dismissed OA 3535 of 2013 wide order dated wide impugned order. Wide impugned order.
22/2017.
Wide impugned order. First off, the apex court, which is that judgment for the YB Patil versus YL Patil. The apex court in YB Patil versus YL Patil, so and so, has held that the doctrine of res judicata operates in Indian legal system in successive stages, and therefore a finding of fact or a norm by the coordinate bench would res judicate the grounds urged by the state for denying relief to the petitioner. First off. Next paragraph. added to the above. The medical chief officer of PHC Godipada, wide a certificate dated 20 March 2026 has given, has said as under. Says. Thus, the services of the petitioner have been continued uninterruptedly and to the satisfaction of
Since 6 to 2010 order. Since 6 to 2010.
correct, but thereafter one more order came in his in that matter, pending matter. I saw that order. First off, though the certificate mentions about a short break in service, comma, that would pale into insignificance because of coordinate benches order dated 2/12/2009, entered in WPC 9335 of 2007, wherein the tribunal's order made in OA 3535 of 2013 came to be affirmed. Yes.
Number 97.
Sorry, 974 of 2005
Yes.
came to be affirmed. First. Next. The case of the petitioner largely fits into the parameters laid down by the apex court in Jago. And also today we saw the 224. Sitaram by the state of Orissa. Sitaram Behera versus state of Orissa. Just put that. First, there is a very strong presumption that where a daily wager is continued in service uninterruptedly without orders of the court or authority court or tribunal, comma, such services are eminently needed for the benefit of the state, comma, subject to all just exceptions into which argued case of the state does not fit. First off, all these aspects have not entered the fray of consideration at the hands of the tribunal. And as a result, the petitioner has been put to put to a great prejudice, warranting our interference for setting the same at not right. First off. Next, in the above circumstances, this petition is allowed. Semicolon. As writ of certiorari shows quashing the impugned order of the tribunal. Semicolon. Petitioner's OA number 3535 of 2013 having been favored, a writ of mandamus issues to the official respondents. Only respond one. Respond one alone.
One.
Huh?
One will be, but it is working under CDM also.
CDM.
But then I say that
CDM.
One and two.
three and
One and two both. Man.
both. A writ of mandamus issues to respondent numbers 1 and 2 to regularize the services of petitioner with the effect from the date his immediate juniors were regularized, that is 2/2/2019. First, however, in the fitness of facts, although notional seniority shall be given to the petitioner, the financial benefits he shall be entitled to after putting in 10 years of regular service, as the law then was regular service. First off, next paragraph. This writ has to be complied with within an outer limit of 8 weeks. And the report of compliance shall be filed with the Registrar General of this court within 1 week next following, failing which the answering respondents run the risk of contempt proceedings. First, the state shall pay a cost of rupees 25,000 to the petitioner for making him to approach the tribunal and this court again and again, which was certainly avoidable. Okay. This cost to be remitted within a period of 8 weeks, failing which it attracts another levy, additional levy of rupees 100 per day per day for the first 30 days and rupees 200 for the days next follow. Okay.
Item 9, WBC 14253 of 2022. Item 10, WBC 37720 of 2023.
Yes.
It's against an order of the Central Administrative Tribunal, my lord.
Huh?
It's against an order of the Central Administrative Tribunal. And the issue involved is regarding treatment of suspension period.
Treatment of suspension period. How it is treated?
Yes, Your Lord. How it is treated. Actually, according to me, Your Lordship, which I understand from the law, the decision regarding the treatment of suspension period has to be initially taken along with the revocation of suspension. And it can be, if disciplinary proceedings and criminal cases are still pending on that day, they can, on the conclusion of them, they can review the same under 50. The rule is 54B. FR 54B. They can review it under 56 of sub-rule 6. And the law settle is that if you
What the apex court said, a review is within 6 months.
Not exactly. They said that it is the part and parcel of the same process. Therefore, once you are revoking the suspension, you have to pass an order regarding treatment of period of suspension. If you don't do it, it shall be treated as on duty. And in cases, the dismissal orders have been upheld, but the period of suspension have been treated as in duty. In this case, there's earlier litigation also regarding external suspension, which was external suspension beyond 90 days was quashed by the tribunal.
That judgment which said the suspension should be periodically reviewed and after 6 months it should be revoked.
Ajay Chaudhary. On that basis, Your Lordship, the CAT judgment, High Court judgment, Supreme Court judgment was there. May I take a Lordship first to page...
No, your proposition is?
That once the day the suspension is revoked, an order...
Along with that, what should happen to suspension period should be determined by the authority at that point.
At that period of time. And if it is not done, then the
full salary.
Full salary has to be paid. It has to be treated as on duty. That's the law which is later. I'll come to that, Your Lord. Let me give the facts first.
No, that's the only fact. What is that fact?
Yes. No, facts means what?
When suspended, when revoked.
Yes, Your Lordship.
2 sentences.
Yes, Your Lordship. That's what it is. Lordship, I'll take a Lordship to first I'll show the law also.
No, not necessarily. We just come with us methodically.
Yes.
It's a very short point.
Yes, Your Lordship.
When were you suspended?
Your Lordship, I was suspended by the order dated. Just a second. The order is dated 11th May 2018 with effect from 30th April 2018.
On what ground?
Your Lordship, deemed suspension, I was arrested for
deemed suspension.
Arrested.
More than 48 hours.
More than 48 hours. I was released on bail.
That is under rule
10-2 of CCA rules 1965. CCA rules 1965. Central Civil Services Classification, Control and Appeal Rules 1965. And then
you were admitted to bail when?
On 5th of April.
You were arrested on
30th of April.
No. Bailed out.
Sorry,
5th of May.
5th of May. 5th of May. Sorry, 5th of May. 30th of April, 5th May. And this order is 11th May.
2018.
Yes, Your Lordship. 3004 2018.
No, we are asking another question to you. your client is arrested
Lordship.
on 28/4/2018.
Yes, sir.
Or he was arrested on which day?
30th.
30th.
If it is 30th, he gets deemed suspension 2 days thereafter.
Yes, Your Lordship.
Is it with retrospective effect or prospective?
But that is why it is deemed. The date has to be from the date when he is arrested.
So he got arrested on 30th.
30th. And if you remain in, that's
Custody
my
for more than
understanding.
48 hours.
That is my understanding of the rules, Your Lordship. I'll bow down to my lords because that is why it is called a deemed suspension. Because if you remain in custody for beyond 48 hours, you will be suspension.
Suppose under section 107 of Evidence Act,
Yes, Your Lordship.
if the whereabouts of a person are not heard of by those who ought to have heard of, then there is a deemed death.
Yes, Your Lordship.
This arises after 7 years.
7 years.
Whether death is from the first day of missing or after the 7 years. Which is that?
Yes, Your Lordship.
In the
It's a
light
very
of that,
valid
we are
question,
asking
Your
that
Lordship.
question.
I think nobody has gone into this aspect. It was because I was a former government servant. This was my understanding as a government servant, which I am placing before my lords. But yes, it's a very valid and very question which has to be also answered sometime, Your Lordship. That's what it is also.
What was the case against your client?
Your Lordship, he was arrested by the CBI for certain. They said he demanded money, not acceptance. Acceptance was not the only demand. The four people who were arrested, Your Lordship. And Your Lordship, the extension of suspension was challenged.
1 second.
Yes, sir.
It is on graft charges.
Graft charge.
How much money he had taken?
No, nothing was taken. They said you demanded 5.
So it was not,
You demanded 5 lakhs.
it was not trapped.
No, not they said that.
What was he?
He was the Deputy Commissioner of Customs.
Customs.
Yes.
Okay. 5 lakhs for doing what?
5 lakhs. He 5 lakhs from another. There was another batchmate, Mukesh Meena.
Anyway,
No, for
what?
That's what I'm saying. The case was pending with another batchman, Mukesh Meena. They said you had discussed with Mukesh Meena about this case. So that is how the case was.
No, it cannot be that plain. Allah is a liar.
The charge sheet is on record. I can read that, Your Lordship.
It cannot be that.
The charge sheet is also on record. We can read the department charge sheet is also on record, Your Lordship. That page from that fact will be page 196. If Your Lordship will say, I can read this fact. The fact is that there were 4 persons involved, 4 deputy commissioners. 3 were 2009 batch, 1 was 2011 batch, and 1 Mukesh Meena was 2009 batch. Some work was pending, and they said that once this person had spoken to Mukesh Meena about this case.
Only about the case.
Yes.
Nothing. No demand.
And on that
for sharing the booty.
No, on that case, the booty was recovered from the gatekeeper of the residential complex where all the 4 were staying.
Well, always it happens that way only.
Whatever it is.
Who will take the money and put in the pocket? It will be sent to some peon or etc.
Yeah.
Who will collect the money and the work will be done by the officer.
Involvement of so many IRS officers for 5 lakhs only.
5 lakhs. That's the case, Your Lordship.
And that too talking.
That sounds very strange.
There 2 containers issue. They
No,
are
on
fixing
law.
these customs. Yes.
He
Yes.
law. He
Yes.
says, as on the date,
Yes.
my suspension came to be revoked. That is 23/9/2019.
Yes. Sir.
Yes.
From
Yes.
yes.
On that day itself, you should have treated the issue whether I should be without salary or not salary. You can't subsequently say all.
He's getting substantial allowance, man.
Substantial allowance, all right. But he is on salary itself.
Because of this court interference, we are restrained for service, everything. But now question is that we cannot ignore the 54B because let's see for a moment the fundamental rules. 54B subclass 6. This is class 6.
Your friend assists the court very well because every time he brings a Xerox copy of the rules, use the rulings.
Yes,
We appreciate that.
Yes. The rules are on record.
Where suspension is revoked,
Yes.
pending finalization of the disciplinary or court proceedings, any order passed under sub-rule 1 before the conclusion of the proceedings against the government servant shall be reviewed on its own motion. After the
That is important. After the conclusion of
That's what it is. The order
But
passed
the-
under sub-rule 1 has to be reviewed in 6. If you don't pass an order sub-rule, what did you review? If there's an order of my lords, only that can be reviewed. That's what the courts have held. I'll come to that. I'll show the laws. If there's an order under 1, whatever order, you can review.
Order under 1 is view.
Yes.
Order under 6 is the review.
Yes. Therefore, if there's no order under 1, what review?
There is no occasion for
Review. That's what it is. That's what the law says, Your Lordship.
Any judgment on that?
Yes, Your Lordship. Up to Supreme Court.
Give that.
Yes, Your Lordship. I'll just first of all,
read one paragraph.
yes, I'll read the paragraph, Your Lordship. First of Your Lordship, I'll take only 2-3 minutes, not more than that.
On relevant arguments.
Only
we are not bothered.
Only
relevance, not even a minute.
No, all relevant judgments I'm talking. First judgment is 221, page Annex 13.
One judgment.
One judgment, then Your Lordship.
Because Article 141 says,
yes.
Law declared by the apex court. It does not say law repeatedly declared by the apex.
Okay, Your Lordship. I'll take Your Lordship to the apex court judgment.
Yes. Which
That
is
is
that judgment?
page 270, Article A60.
Read.
Yes, Your Lordship. I'm reading para 20. With this background, we revert back to writ petition number 916/2007 and such and such. As far as writ petition number 916/2017 is concerned, let us recapitulate that it arises out of OA number 1.
All that may not be necessary. Go to the law laid down.
Yes. The para 21.
Yeah.
The High Court, while dealing with the writ petition, took a view that in case order revoking the suspension did not deal with the suspension period or payment of salary for suspension period, order revoking suspension cannot be treated as void or non-est. The only effect thereof would be that the competent authority is precluded from exercising its power under FR 54B, and the legal position was that if while revoking the suspension or within a reasonable time thereof, no order is passed pertaining to pay and allowances for the period of suspension, the authority is denuded from passing such order. The necessary consequence thereof would be that the government servant is entitled to. Then, and para 22 says, according to us, the aforesaid approach of the High Court under given circumstances is without blemish. The High Court has relied upon judgments of the CAT, actually, which talks about this subject. And Your Lordship, there's a latest judgment also on this subject. I'll hand it over, Your Lordship. Actually, it pertains to my personal case where I was given a penalty which is under challenge, but the period of suspension has been treated as on duty with interest, Your Lordship. Relying upon the Supreme Court and High Court judge in Vijay Kumar.
High Court.
Para 8, if I just will say that they talk about the Vijay Kumar Agarwal, Your Lordship.
Paragraph is
8, Your Lordship.
1/8.
Only 8. And then paragraph 18, they discuss FR 54B. Then para 19, Your Lordship. A reading of the above would show that in accordance with this FR 54B, the order regarding the treatment of the suspension period has to be passed by the competent authority at the time of reinstatement by way of a specific order. Though in accordance with procedure prescribed under sub-rule 3 to 6, the competent authority is empowered to direct payment of full or part and allowances, even if the suspension is revoked pending finalization of the disciplinary and court proceedings. An order is still to be passed under sub-rule 1, which may on the conclusion of such proceedings be reviewed by the competent authority on its own. 23 is fine, yes.
Right.
Your Lordship. From the above, it is evident that not passing an order under FR 54B1 immediately or within a reasonable period of time, passing of an order revoking suspension denudes the competent authority of the power to pass such an order thereafter. The effect thereof is that the employee officer is stated to be as on duty during the period of his initial suspension, as well as therefore he is entitled to full pay and allowances.
That order was not passed.
No, that order was not passed.
Sub-rule 6 was not passed.
The sub-rule 1 was not passed, therefore 6 was.
Even far below that it will.
Yes. That they said will not pass, an order will only pass after that. That is what was challenged before the tribunal.
Your suspension is dated
the revocation
34/2018.
Yes, Your Lordship.
And the revocation is?
Revocation is, the date of revocation is 18 June 2021, but with effect from a back date, Your Lordship. That is with effect from 28/9/2019. What's the second version? I'll just get it.
28/9/2009.
24/7/90.
Huh?
24/7/90. Page 114, Your Lordship. 144. 144. 24/07/2019.
Did you claim, your claim was rejected?
Your
Did you
Lordship,
make any claim saying that?
yes, Lordship, what has happened?
No, we are asking.
Yes.
Did you make any claim?
Yes, Your Lordship.
When it was made?
Your Lordship, I'll just say that. First of
Give
all,
that representation.
Your Lordship, representation is not required here, Your Lordship, because under Rule 22 of CCA rules, this is an order by the President. There is no appeal against the order of the President.
18/6/2021 order did not mention
Yes, sir.
that you are not entitled to anything. That it did not. This it did not say under Rule 6 because it did not go to Rule 1 also.
Yes, that is right. May I read paragraph 12 of page 144 when revoking the suspension? Whereas, since suspension is being revoked pending finalization of the disciplinary or proceedings, the treatment of suspension this 30/4/2018 to 23/7/2019 and pay allowances for the suspension period shall be reviewed only after your own motion on the conclusion of the disciplinary criminal proceedings in terms of FR 54B6. The question is, if you don't do under 1, you cannot do under 6.
Subsequently, you cannot.
That's
Because
what-
under 1 itself, we have not done.
Yes, sir.
Unless, since 1 is internalized in sub-rule 6, we will not travel to sub-rule 6 is your contention.
Yes, but I was reading the judgment I handed over also. Para 19, there's one sentence which I wanted to read.
Apart from 23.
Yes, para 19, only one sentence.
Very good. We read, no
Yes.
problem.
Para 19, a reading of the above would show that in accordance with FR 54...
Paragraph?
Para 19, 19. FR 54(1).
1 second. Reading of the above would show
That in accordance with FR 54B, the order regarding the treatment of the suspension has to be passed by the competent authority at the time of registration by a way of a specific order.
though in accordance with the competent authority is empowered to take the payment of full or part pay upon even if the suspension is revoked pending the finish of the order is still required to be passed under sub-rule 1, which may on the conclusion of proceedings be reviewed.
And then
This order to be passed as such review in accordance with. Why they say sub-rule 3? It is sub-rule 6.
No, the 3/4 gives other circumstances
Okay.
here. Other circumstances. And 20, Your Lordship, in the present case, from the bare perusal of the order dated such and such passed by the competent authority revoking the suspension of the petitioner, it is evident that no specific order under FR 54B1 passed. The question of review thereof on conclusion of this proceeding therefore does not arise.
And this order of the Delhi High Court is affirmed by the apex court.
Yes, Lord, it has been implements.
Implement.
Yes, it has been implemented.
No, but the learned judge says this VV is implemented in approved by the apex court in SLP.
Yes, that judgment which I read, first I read out the Supreme Court judgment. This is the judgment they have relied upon. The same judgment they have relied.
Yes, Mr. Party, what is it? Is there order under Rule 1, sub-rule 1?
There is 143, let's say, page 143.
Is there such an order? Is our question. You are asking us to read the pages, we'll read. That's another question. Answer the question.
It is the only order
Is
in
there-
respect to
Sub-rule 1 order. That is his case. No.
An order was passed. An order was passed which is annexed, that is
We'll ask him 1 second. We'll put clarification.
Yes.
Do you dispute that he was suspended by way of deeming provision under Rule 10(2)? Deeming provision is 10(2)
Yes, it is.
because of the arrest and detention beyond 48 hours.
10(2)A.
10(2)A.
Yes.
That was on 30/4/2018.
30/2018. Yes.
Correct.
Yes.
Then revocation was with order dated 18/6/2021 with retrospective effect from 24/7/2019. Do you dispute that?
Yes, removed on 7 to 2019, not 21.
No, up to 23/7/2019, he was under suspension, na? See, you have made order of revocation on 18/6/2021.
Yes, yes.
And that would take, it would be with retrospective effect from 24/7/2019.
Yes.
After
It is
this,
correct.
after disposal of the SLP. Yes.
24/7/2019.
Yes.
Very good. In your order dated 18/6/2021, did you tell him you are not entitled to pay and allowances?
Because this, that's why I would say the 54(6) is the bar for which we can.
You cannot go to 6 at all. Unless you make an order under sub-rule 1, how can you travel to sub-rule 6? Sub-rule 6.
Consequence,
Sub-rule 1
consequence. I concede to that. It is a consequence. But thing is this, unless until the authority will not clarify from the possession of law. Suppose he is suspended, it is admitted. We are giving substance allowance. And the DP is pending. In the meanwhile, 54(6) will taken care along with 61 according to my law.
No.
But
No.
my lord's view is that once we will not invoke this 51, we cannot
Not travel to 6
Yes.
at all. Because 6 says, as he rightly puts it, with his rich experience in the department, 6 internalizes 1.
Yes.
Unless 1 you travel to Ganga, you can't say that you have traveled to Gangotri by water. Or you can independently go to Gangotri is another thing. But his case is, it is normative. Law is like that, what we should do.
My lord, this order is not binding on this. Delhi High Court's order. Refer to that.
So no.
Delhi High Court said in our favor.
Which one?
Yes, I'm just giving this.
No, it's a central rule. Kusum ingot will come in the way. If it was a rule relating to particular state, we'd have understood. Where any high court interprets central rules, then that applies to every high court. It's not just persuasive. It is binding. As if it is a coordinate bench.
For reference, I'm saying, I cannot say this. It will binding on this, my lord.
I know Prashant Sinha, his suspension was never revoked, Your Lordship. He's still under suspension. If I'm not wrong, now his suspension was revoked, he has been posted to Bhubaneswar. If I'm not wrong in this.
What the delay could say?
He challenges extension of suspension, which was a decline of tribunal.
Where is the law declared in this? Where is the law declared? Absolutely no discussion on law.
Discussing.
Not what we should do with that order.
That's right.
Only the ratio decidently of a judgment binds us.
Is a bind, yes.
Not on. That's another.
But Lordship, we have dealt with the matter, Lordship, for a moment 144.
Your suspension is not rescinded till date.
No use.
It is rescinded on
Yes.
18/6/2021.
On that 2021 order,
That was on the basis of a CAT judgment upheld by High Court, upheld by Supreme Court.
on that 18th June 2021 order, for a moment, Lordship, is in paragraph 9. Para 9. The next page, 144. Whereas, may I read well?
54B6. That is on the channel.
Yes. That is under check.
That is
We have given the region. What I'm saying, we have given the region.
It does not occur.
Assume different law.
On law, on bias, without rule, we would have held against him. Because we are human beings. If a person is involved in graft charges, we carry some bias. But when law says, law is heavily loaded in his favor.
Only barricade is that because this we have not touched the 54.
It's 6. That is the only.
They should have passed an order under 143.
Should have passed. Then review was possible.
Then review was passed.
If you will go, other thing will go. With regard to the ratio is concerned, that is.
Right. Kindly be seated now. Sit down. Please sit.
May I leave?
Very good. No, next. Petitioner, a central government civil servant of Customs Department, he is knocking at the doors of High Court for assailing Cuttack Central Administrative Tribunal's order dated 18/8/2023, whereby his OA number 381 of 2021, essentially seeking full pay and emoluments for the suspension period between 30/4/2018 and 23/7/2019 has been negative. Correct?
Not
Absolutely. Next paragraph. Learned counsel for the petitioner, pressing into service a Delhi High Court decision in Tushar Ranjan Mohanty versus UOI 2025 THC 6756 TB, more particularly paragraph 9, 19 and 23,
20 also.
19, 20 and 23 submits that where the suspension is revoked, without saying anything about the entitlement of the employee for the pay and allowances during the suspension period, the same needs to be granted to him. First, he takes the court through the provisions of 50
FR 54.
Fundamental Rules
54.
Rule 54 capital B, capital B 1 and 6. In support of his stand. First one. Learned DSG Mr. Party, ably assisted by Mr. So-and-so, vehemently resists the petition, making submission in justification of the impugned order of the tribunal and the reasons on which it has been structured. First off, he also placed the reliance on, where is that order, Justice Commissioner of Judgment order? We gave it back since you referred to that. Yes. On a decision of Delhi High Court in WPC 6645/2023 between Prashant Kumar Sinha versus Union of India, disposed of on 26/5/2023 in support of his contention, on which the tribunal's order is constructed. Next one. Having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant indulgence in the matter as under and for the following reasons. Number one, the foundational fact as to the suspension of the petition, deemed suspension of the petitioner under section 10(2)(a) of CCA rules 1965, because of his arrest and detention beyond 48 hours, wide order dated 30/4/2018 is not in dispute. First off. So also, the revocation of suspension order. So also, the suspension revocation order dated 18/6/2021. Kindly sit down. You can answer from sitting only. 18/6/2021 with retrospective effect from 24/7/2019.
23/7.
23 was the last date of suspension.
Therefore, with effect from
24.
20. With effect from 24/7/2019 is not in dispute. First of all. Learned counsel for the petitioner is right in placing reliance on the decision of the apex court, the Delhi High Court, in Tushar Ranjan Mohanty Supra, to the effect that unless the revocation order specifically says as to what emolument should be paid or denied to the employee and for the suspension period, his salary based upon the admissible pay scale and the allowances cannot be diminished. First of all, he also tells us that the salary that accrues to an employee virtually constitutes a property under Article 300 capital A of the Constitution of India, and that denial of a part of that, part or whole of that, would amount to vigar prohibited, proscribed under Article 23 of the 23 of the Constitution. Wide. The High Court of Gujarat versus State of Gujarat. State of Gujarat. 96, 97 Supreme Court. Just take a look. First of all. Next paragraph. The Delhi High Court, having considered the text and context of FR 58,
54.
54,
Yes. 54B.
54B, at paragraph 23, has observed as an first of all, the above observation is made keeping in view the apex court decision keeping in view the imprimatur granted by the apex court in Vijay Kumar Agarwal versus UOI, wide SLPC 6393 of 2012, disposed of on 6/10/2015, which affirmed the decision of Delhi High Court only.
Yes, sir.
Decision of Delhi High Court in
That's in Vijay Kumar Agarwal University.
In Vijay Kumar Agarwal versus Union Law.
That's writ petition, your lordship?
No,
No, that is division bench.
Yes,
no,
that is
that also, that is division bench.
Division Bench High Court, that is at page 270. Your lordship.
No, which is that? Is it reported?
The report, it's the judgment I have put on record, your lordship, page 270.
No, that's something.
No, just only like this. Write it.
That's writ petition 916 of 2007. Page 237, your lordship.
WPC, in WPC number 916 of
2007. Yes, page 237. Right.
All right. Next point. The apex court in But in Kusum Ingot is 2004. Kusum Ingot versus so and so, Union of India has observed that when a piece of central legislation or subordinate legislation is interpreted by the apex court, interpreted by one high court, ordinarily the other high courts have to follow the same, subject to very few exceptions. First one, you find out that Karnataka judgment where Kusum Ingot is construed by the division bench. The division bench, Justice Nagatma was a member of that bench. Matter arose under the Indian Divorce Act, 1910. All right, that we are there. Refer to Karnataka division bench judgment on Divorce Act. Divorce Act 1910. Okay. File it out now. Next paragraph. One more sentence. The reliance of Mr. Parity on another decision of the division Delhi High Court in Prashant Kumar Sinha would not come to his rescue, since the said decision nowhere refers to any rule, much less FR 14, 54B. First, no discernible decision or principle arises from the brief facts stated in the judgment, which again runs into short 3 paragraphs, comma, the last paragraph being a one-liner, in which the petition is dismissed. First one, it hardly needs to be stated that a ratio of a decision has to be churned out by applying known doctrines like Wambach's test, Professor Wambach's test, or Professor Dr. Upendra Bakshi's test. First off, there is absolutely no scope for invocation of these doctrines at all. First off. Next paragraph. All the above has not animated the impugned order of the tribunal. First off, the tribunal has not considered the matter in the right perspective, and therefore a great prejudice is caused to the employee, which needs to be set at naught. And we do. First, in the above circumstances, this petition succeeds. Second, the writ of certiorari issues quashing the impugned order of the tribunals. Semicolon. Petitioners OA number so and so having been favored, a writ of mandamus issues to pay to him all the emoluments minus the subsistence allowance drawn for the suspension period between 30/4/2018 and 23/7/2019. First off, this to be done within an outer limit of 8 weeks. And if delay is broken, the emoluments payable would carry interest, monthly interest, at the rate of 1%. 1%. Monthly. 1% for the first 1 month and 2% for the months next following, which may be recovered from the erring officials of the department. Yes, otherwise
The criminal case is over.
No, it's still going on. Only Lordship, may I only request me?
it works. Even if a criminal works, has to be that is that actually somebody is won't take that because of this. But so far won't get up. In Gujarat High Court versus State of Gujarat, the apex court said asking the convicts to work without wages is violative of Begar. And therefore convict should be made payment. He is not a convict as it.
No.
We wish that he will not be. That's another thing. Now, whatever emoluments are admissible to a civil servant, that cannot be denied to him because it partakes the character of property under Article 300 capital A. And secondly, if you ask him to work but take lesser amount, that itself is violation of Bega. The very beautiful judgment of that.
He is our officer, but thing is that he must be honest and this is the only thing.
We don't know. If you are not honest, why did you
Only my
revoke suspension?
my lord has given 8 weeks. He said 3 months time.
3 months. That's right.
Only one request may I make, Your Lordship. When the official, the law says that paid salary, Your Lordship, that should be treated as a duty. Only then that is salary. Because that, only then that is
why I am objecting. Yes.
the law.
Section of law, 54B itself. My brother has put it right. Because 54B is to protect such officials only. You amend 54B. And you file it, make it retrospective.
Separate pair. Let them.
So it is the prayer is there.
Not a issue.
No, again, one more thing. We
Your
don't.
Lordship, it is there in the prayer of the way, Your Lordship.
This revocation of suspension is at the intervention of court's order.
Yes, Your
Court's
Lordship.
order.
Court-
Went to apex court.
Up to apex court.
That the one sentence mentioned that the suspension period shall be treated as being on duty.
As in.
Put it somewhere. We'll come back.
Yeah, Lordship. Next is also ours. Similarly, connected issue here.
Well,
Lordship, thank you.
May it please your lordships. My lord, I may be kindly permitted to appear virtual, my lord.
yes, sir.
Oblige, my lord. It's a very short point and a
Yes.
legal issue. Yes. My lord, we are impugning a CAT order, and which, my lord, also now conflicts into a contempt proceedings on the ground that on the date of retirement, you have not issued a charge sheet, and therefore it is not maintainable. Overlooking the old law and the present law on when department proceedings have been initiated and suspension is anterior in time, the same course will follow suit, my lord, will well settle, will show that to your lordship. The tribunal makes 2 mistakes. It follows, my lord, a Delhi High Court judgment, which does not, my lord, deal with a departmental proceedings, it deals with criminal proceedings, number 1. Number 2, the matter went to the Honorable Supreme Court, where they have clarified that the officer who was, my lord, imputed has been cleaned up with all the charges. Therefore, no merit lies on the matter at all. So it's a failed judgment, my lord, which has been followed by the CAT. And then, more than going into the jargon and technicalities, let me show 2-3 dates and the provision directly, my lord. Your lordship has to interpret the provision, the old law and the new law. They are identical as far as this provision is concerned. Will your lordship see only 2-3 dates, my lord? Here is a case where the officer has been suspended and my lord now charge sheeted on the ground of disproportionate asserts to the extent of a few crores. That's what, my lord, the CBI has unearthed. So it's a case of a disproportionate assert case. My lords will see the following. Will your lordship be kind enough to see our petition page 23? Just a couple of dates I'll give, my lord, and then go to the provision.
Yes.
Page 20, may I show, my lord? Page 23. It's the starting point of the disciplinary proceedings. Just for date 6.
Our system is not mirroring the correct image of Mr. Venkatraman.
Oh my God.
We can make out by blurred the vision and your voice also. Yes.
Oh my, I'm so sorry, my lord.
Absolutely no issue. No, we have to say sorry because it is our system. Yes, Mr. Venkatraman.
I hope my voice is clear.
Yes, your voice is clear. Clear and loud.
In fact, I heard your lordship saying Article 141 doesn't say the rule of law will apply, not rule of law repeatedly. Just heard what your lordship will say.
In fact, every time we are facing, they will give 1 dozen judgments and give us in this judgment, it said, in this judgment. Therefore, often we keep on saying that.
I will keep your lordship away from that torture this time.
No, that's not crazy. Sometimes we say certain things for humor also.
Yeah.
More than wisdom, for humor also.
Well, our pure first principles, page 23. Yes. But page 23 is the commencement suspension order and the commencement of the disciplinary proceedings. Date may be noted, 22/11/2019. This may be an important document. Whereas disciplinary proceedings are being contemplated against so-and-so, therefore, President in exercise of under suspension with immediate effect. So he was suspended on 22/11/2019. That is the starting point in terms of the rule, which I'll show to your lordship in a minute. Then, my lord, the second document, my lord, is, please see page 25.
Which page, sir?
25. Annexure 2, 6/1/2021 issued by the CBI. Pursuant to so-and-so. In this regard, its informed case so-and-so is under investigation. CBC Circular 2000 has stipulated that revocation of suspension of a public servant facing serious charges of corruption should be considered in a routine manner. Therefore, the suspension officer may be continued. So suspension continues.
Is this the order or this is recommendation?
A recommendation, a direction. It's not an order. It's more in the nature of a advisory opinion. Correct, my lord. And we have continued the suspension. There is no doubt about it that we continued the suspension till his retirement.
The order was made. This is not order.
It's not an order.
Covered you are faithfully, this, that, etc.
It's a letter.
It's another officer.
Yes. It's a letter.
Intra-departmental communication.
My lord is right. Absolutely right. Conceded. And what we are continuing, we continue with the suspension. Is retirement mistake? Retirement is mistake.
Is there a continuation order? Do you have order continuing the suspension?
We have order continuing the suspension, which is not under doubt, my lord. I'll just show it to your lordship. That's not no doubt about it. Your lordship made it one more date. He retired on 31/1/2022. Still that date, suspension was in vogue. It's the instructions I produced there. Necessary support. In fact, that is something which my friend has not disputed.
That is correct. Factual.
Correct.
Yes. So, Mulad, suspension continues. So, Mulad, he retires on 31/1/2022. So, Mulad, please see.
One more stage. This Annexure 2 advisory is dated
6/1/2021. My lord is right. 6/1/2020. My lord is right. And the third date is retirement is 31/1/2022. And the sanction order, my lord, is Annexure 3, 23/3/2022.
Annexure 3 is
sanction order.
a sanction for prosecution.
Sanction for prosecution. 23/3/2022.
Is it under 1988 Act, PC Act?
Yes, yes, yes.
Is it PC Act or Section 197 of CRPC?
I'll just check in a minute and revert on that. I'll just check in a minute's time. So, but the point is, the only legal issue is, these are the 3 dates which I thought I should give to your lordship. He went back, he went to the CAT, his subsidy allowance were increased for 50%. All those details, let me not trouble your lordship. The CAT order is 23/7/2024, which is, my lord, Annexure 5, page 60. 23/7/2024. Annexure 5, page 60. And your lordship may kindly see para 6 and 7.
Paragraph 6 and 7. Yes, sir. Subsequently.
My lord is right. Subsequently, similar question as to whether, while continuing under suspension, allowing an employee to retire on attaining the age of superannuation without any objection, the order of suspension automatically gets revoked after the relationship of master and servant ceased to exist, came up for consideration before CAT, Delhi, in Surendra Kumar Gupta versus Union of India. The CAT Principal Bench, New Delhi, taking into consideration the earlier decision in R.S. Nayak, S.P. Jain, H.L. Mehta, and various other provisions of so-and-so rules, and the fundamental rules, etc., 56, by an order dated 22/2015, held that since the applicant therein, while under suspension, was allowed to retire by the respondents on attaining the age of superannuation without any objection, the earlier period of suspension automatically gets revoked and the relationship of master and servant between the government and the employee ceased to exist on retirement, and his status as an employee gets altered. Accordingly, the respondents therein were directed to release the benefits and pay the allowances. On examination of the facts and issues involved in this case, vis-a-vis the case law to be above, we do not find any ground to differ from the view already taken by the principal bench that since applicant in the instant case, while under suspension, was allowed to retire by the respondent on attaining the age of superannuation without any objection and without any initiation of departmental proceedings, the order of his suspension automatically spends its force, becomes redundant, ceases to exist, resultantly entitling him to pay and other allowances for the period of suspension as if spent in duty. Hence, the respondents are directed to pay the applicant his salary and allowances with effect from his date of suspension till his retirement, of course, minus subsistence allowance already paid to him within a period of 60 days from the date of receipt, so-and-so, so-and-so. Now, we are also facing a contempt. Now, Lord, please see, this CAT went to the Delhi High Court, the principal bench, S.K. Gupta's case, which we have kept it, my lord, at page 125, Annexure 7.
Mr. Venkatraman.
Yes.
An employee during suspension, the vinculum juris of employer-employee continues. The suspension cannot overstay the determination of the vinculum juris.
Right.
What is wrong with this order?
Now, unfortunately, the rule which governs the field was not cited. The rule provides the connect which your lordship wanted to. That's the point. The rule is directly on the point against it. I'll show the rule straight away. The rule gives the benefit if suspension is anterior in time, then, my lord, the proceedings will continue even on the date of retirement. If action has not been taken, doesn't matter. He continues to be only a suspended employee, is the rule. The old rule, Rule 9, the new rule, Rule 8. Both I'll show. The rule was amended in 2021. This clause has been retained intact. Very importantly. So we'll show that. What got misled was this. What got misled was this. Please come to the Delhi High Court, against which the principal bench went to the Delhi High Court. My lord will come to page 125. This is the S.K. Gupta's case.
Venkatraman, we will do that. But before that, since you are on the legal principle,
So we'll show the rule itself.
rules. Let us see the rules only.
Straight away. My lord, we'll see the old rule and the new rule. Please see the 1972 rules, Rule 9.6. We have. Mr. Party will give you
Can
the
I
copy.
only say one thing?
Let me finish my case.
I'm only of the pages, that's why.
Pages,
Yes. I have put the new rules in page 346 of my written submission.
346.
Of my written submissions, Annexa R8.
I'll go to the old rule and show old rule 1972 and the new rule 2020. Both are identical. Let's see both.
I concede to that fact. A lot of the new rules are there. So page 346.
But the Delhi High Court considered old rule.
Is 8.
In old and new rule, the rule is retained as legal position is retained intact.
Intact. Absolutely
Let us
intact.
see,
Yeah,
let us read the old rule.
Yeah, let us see the old rule because that was what Delhi High Court considered. There are two parts to the old rule. Delhi High Court considered the second part, not the first part. That's the mistake. Not the mistake of the court, the mistake in understanding the law. Delhi High Court has not committed an error. But please come to the rule.
The rule.
We are showing about 1972 rules, Rule 9.6.
72.
Rule 9.
Can we know the rules? Which are those rules?
Rule 9, pension rule, CCS pension rule, 1972.
CCS pension rules.
Only thing I would like to say, Your Lordship, before the retirement of this officer, the new rules had come into force in 2021.
No, learned ASG is saying
Yes.
that particular position is kept intact.
Yes, Your Lordship.
I want to show the continuum.
I'm conceding to that.
Yeah. I'm happy.
Rule positions. 72 rule.
Rule 9. So, Party, I hope you have the copy to be given to the court.
Mr. Party, do you have the copies of the? If you
We have a new rule, old rule.
No, new rule is 21.
21. Yes.
New rule is 21.
That will have.
I'll go to the new rule itself. Lordship may take the new rule.
So
I want to show the history, no problem. Because Delhi High Court referred one portion of the rule and failed to refer the other portion. That's the error which I thought I should. That's why I wanted to refer to the old rule. Doesn't matter. Let's take the new rule, Malad. No, let's take the new rule.
No, new rule also we can read because he admits that the
Yes.
old rule, new rule, no change.
The old rules were 9, in the new rules it's 8. Only difference is that.
Yes. Malad, it is Rule 8. My lords may come to Rule 8.
1 second, sir.
My friend has it in his compilation. Rightly.
Rule 8 of old rule.
New rule.
New rule.
Yes. Old rule is 9. New rule is 8.
Of which year?
2021.
2021.
New rule.
That is PS 405.
New rule is, Your Lordship, 20th of December 2021.
Page 340. Page
Good rule, page 340.
The old rule, new rule is page 346 of my written submissions, Annexure R8. R8.
20th of December 2020.
21. And he retired on 31st of January 2022.
Will come to it. Kindly be seated.
Yes, sir.
We will not pass any order without.
Only assisting for pages, nothing else. I'll not
You can
discuss.
sit and tell us, no problem.
Yes.
Power to visit or withdraw pension.
Yes. In which, please come to Sub Rule 8.
Yes, sir.
The president may, at any time, either on his own motion or otherwise, review any order passed under these rules, where extenuating or special circumstances exist to warrant such review, or when any new material or evidence which could not have been produced or was not available at the time of passing the order to review, and which has the effect of changing the nature of the case has come or has been brought to the notice. Provided that no order enhancing the amount of pension or gratuity to be withheld or withdrawn shall be made by the president unless the government servant concerned has given a reasonable opportunity of making a representation against the proposed so-and-so. So up to Rule 8, 1 to 8, my lord, is the various capture. Then, my lord, there is a common explanation for the whole rule. My lords may come to the explanation. For the purpose of this rule, there are two clauses, Clause A and Clause B. My lord has it?
1A, 1B.
Yes. For the purpose of this rule, departmental proceedings shall be deemed to be instituted on the date on which the statement of charges is issued to the government servant or the pensioner, or if the government servant has been placed under suspension from an earlier date on such date. And second,
Date of suspension is the relevant date.
relevant date. And what clause B? Delhi High Court considered clause B. And B, judicial proceedings shall be deemed to be instituted. Subclause 1.
So that is judicial proceeding. Mr.
I read it for
judicial proceeding.
Yes, but I just read it for completion's sake. I read it for completion's sake because Delhi High Court referred only this. Judicial proceedings shall be deemed to be instituted in the case of criminal proceedings on the date on which complaint or report of a police officer of which magistrate takes cognizance is made, and in the case of civil proceedings on the date the suit is filed in the court. So 3 dates. Department proceedings, anterior in time, suspension. Criminal proceedings, police report, a police complaint or report.
Charge sheet is filed.
Cognizance. And 3 more, civil proceedings when you file a suit.
Complaint is presented.
That's all. So this is identical to earlier Rule 9, subclause 6A and 6B are identically worded. So therefore, this has not been considered at all by the CAT. It went by one order of the principal bench, which was a judicial proceedings, number 1, not a departmental proceedings, number 1. In which, that is why I wanted to now show the Delhi High Court. Please see what the Delhi High Court found as a matter of fact in that case which went from the tribunal. Please come to page 125.
It was not a case of disciplinary proceeding at all.
Please see what I wanted to show what has been referred to. He has been suspended, but please see para 2. This is the finding of fact. There is no reference about any departmental proceedings. Para 2 records the fact, page 3, he was arrested and remanded to judicial custody for more than 48 hours, whereupon he was deemed to have been suspended from the date of his arrest dated 26/6/2012. He continued to remain under suspension until superannuation on 31/5/2012. This is the factual position. Then, my lord, please see what is found by the court in paragraph 9. It's referred to the old rule 9(4).
In the case of government servant
who has retired on attaining the age of superannuation or otherwise, against whom any departmental or judicial proceedings are instituted, or where department proceedings are continued under sub-rule 2, a provisional pension as so-and-so shall be sanctioned. Then, my lord, it did not refer to 6A. It referred only to 6B, which is criminal proceedings. If your lordship sees, I will just read for academic, what does 6A say? Identical to explanation 1A of 8. 6A says, department proceedings shall be deemed to be instituted on the date on which statement of charge is issued to the government servant or the government servant is placed under suspension from an earlier date on such date. That is not come up for consideration in Delhi High Court. What is come up for consideration is only the criminal case. There, my lord, the court finds as a matter of evidence that criminal case has been instituted earlier. So it referred only to 6B and not 6A. Then, my lord, please see para 10. A reading of the aforesaid sub-rule will show that on the date of superannuation,
judicial proceedings only.
That's all. And my lord, what happened? This is on fact. The matter went to the Supreme Court. And the Supreme Court, my lord, this is the order passed by the Honorable Supreme Court, which your lordship get Annexure 8, 138.
That was a case of acquittal.
That's all. So everything, and my lord, a final, this is 22/6/23. The next date, my lord, a detailed it covers the whole thing. What needs to be given, how needs to be given, what pension should be given. Everything has been detailed because he's been acquitted. Second order gets passed on 13th November 2024. So, my lord, the order sought to be relayed by this CAT, which is impugned in a lordship court of a principal bench, was on criminal proceedings, not, my lord, departmental proceedings, finally discharged and acquitted, and the Supreme Court has given all the benefits that is to be granted to an acquitted person. So the reliance placed in para 6 and 7 of the CAT order but does not stand scrutiny on facts and does not stand scrutiny on law, because what was considered there is old 6B, which is corresponding to explanation 1B. What is relevant in our case is old 6A, corresponding to explanation 1A. In terms of 1A, your lordship may note the dates. But we have suspended him on 22/11/2019. And he has retired on 31/1/2022.
No, Mr. Venkatraman, where is the order continuing his suspension?
I'll submit it to your lordship. My friend doesn't dispute, but we'll give it to your lordship. He was continuously earning
suspension till his retirement on 31/1/2022.
That's a fact.
And just to clarify one thing only.
No, 1 second. Let him come. Then we'll come back.
Yes.
So, well, the fact that the suspension continued till 31/1/2022 is not under dispute, fortunately. Even the CAT or nowhere, there is a dispute on that. So suspension continues and he retires. So, my lord, departmental proceedings anterior in time. The charge sheet, of course, was now filed. The charge sheet has been now filed on 1/11/2024. Charges in the criminal law, but that is later in time. That doesn't, my lord, in any way take away.
Will not be relevant for our purpose.
I'm just putting for the completion of date purposes.
One small clarification.
Yes.
Whether an employee who was in suspension at the time he demitted office on retirement should be paid full emoluments or not is one question. Whether suspension of an employee on demitting office on attaining the age of superannuation is another question. Whether suspension continues or will not continue is irrelevant, actually.
I will answer the second question, which may answer the first question also in terms of the rule. Lord, once rule says if suspension happens prior to retirement and suspension is not under dispute, then his retirement is non sequitur for, my lord, any vindication or extinguishment of any rights. That is the whole purpose. Otherwise, the rule will be preserved.
No, what I was, we were thinking was, suspension by its very logic and idea presupposes person being in employment.
Correct.
Retirement will cut the umbilical cord between the employee and the employer.
Yeah.
The existence of umbilical cord is a sine qua non for continuation of the suspension.
Yes.
But question is this. Question is whether suspension continues or not is not the question. Question is, in our view, just we are putting it to you. We are thinking aloud, that's all.
As it pleases your lordships.
Once an employee is suspended in contemplation of criminal proceeding or disciplinary proceeding, and he retires during the continuation of the suspension, it is not that his suspension is continued, but on account of anterior suspension, he will not be entitled to the emolument which otherwise he would have drawn, but for suspension.
Absolutely. That's one.
This appears to be the correct position of law.
That's certainly one way to look at it. We don't have a problem. But now,
suspension. Where is the warrant? Even in the rules which you have read now,
yes.
Where is the warrant for assuming that suspension would continue?
Yes.
Where is that wording? Where is the text context of the rule?
Whereas the CAT has, if you see the impugned order of the CAT in para 7, it does exactly the opposite. Very precise. In fact, it can't be put more precisely than it.
Mr. ASG, we are not on that.
Yes.
You are structuring your argument on the proposition suspension would continue even after superannuation.
Correct.
For that, there is no warrant, textual warrant in the old regime or in the new regime.
Yeah, no, I'll put it this way. I'll answer it this way. There is nothing in the rule to say, in fact, we have to read the rule this way. When a right is taken retrospectively to a date earlier in time. Unless the rule says the right abates on his retirement, we cannot read that the right gets extinguished. That's the law. That's the law we have to reinterpret. Otherwise, the whole law goes. Otherwise, this law becomes completely without any. It will serve no purpose. So everybody will retire and it will abate. The law should say, notwithstanding it is anterior in time, on retirement, this will get abated. Is not what neither the old rule says nor the new rule says. In the absence of an extinguishment or an abatement, then, my lord, the suspension has to continue irrespective of the status. That is the purpose of the, my lord, we have to give a purpose to this rule. Otherwise, we'll defeat it. Retirement will defeat. A natural retirement will come to a closure, will result in a natural abatement of all pending proceedings. Whoever retires, so somebody has to drag on the proceedings till retirement. That's all. That cannot, an interpretation advancing such an objective will be self-defeating to the very rule. Lordship should not, I'm glad your Lordship raised this question. We have to preserve the rule. We cannot dilute the rule. Is, my lord, our respectful answer to this. It's a very, very relevant question. I'm deeply guided by this. Whereas now, what does this say? Para 7 of the order says,
When you examine that, there are two books on law of suspension.
yes,
One is by Colonel Nilendra Kumar.
okay.
Another is Justice Rama Joyce, whom you know.
Yeah. Great scholar.
He's services under the state, to which Professor Upendra Bakshi has given introduction. There he has treated it as a separate topic.
Okay.
How that is answered, I do not know. I do not remember.
We'll read it and come back.
Anybody has studied.
It's a pleasure, my lord. To appear, and when I asked who is the judge before whom I have to appear, I was hesitant because I don't know whether I'll do it. They said it's before your lordship. I said, no, I'll rob the opportunity. I won't appear. Long time since I appeared in your lordship's court. So it's a pleasure to address it. My lord, we'll work on this. We'll definitely work on this and come back. We have no difficulty. But my lord, your lordship will only bear one aspect in mind. The fact that the rule wants to continue, the explanation very clearly says, what is the purpose of the explanation? For the purpose of this rule, a departmental proceeding shall be deemed to be instituted. So it can't abate. Deemed to be instituted on the date on which the statement of charges is issued to the government servant or pensioner, or suspension from the earlier date. So deemed to be instituted cannot abate. The purpose is lost.
The purpose is to perpetuate.
Perpetuate, not to kill it, not to extinguish. That's the whole purpose. Whereas, in the second, my lord, judicial proceedings shall be deemed to be instituted with the timelines. Now, the timeline is only prospective. My lord, very interesting. I'm guided, my lord. When we argue, we learn a lot in the process. When a court engages in a discussion, it's a delight to argue. Please see, my lord, it is the clause B is prospective. Clause A is retrospective. Clause B says, judicial proceedings shall be deemed to be instituted in the case of criminal on the date on which complaint or report of police officer or which magistrate takes cognizance. B, in the case of civil proceeding, the date is filed. Whereas here, it dates back to the date of suspension. Of course, in these two cases also retirement could be later. I'm not denying it. Can be ended. So well, the point is, in our case, we are falling under 1A second part. If the government servant has been placed under suspension, two questions your lordship asked. Date of suspension is, my lord,
2019.
And my friend also conceded, we'll also place the paper required till 31 January 2022 suspension.
Retired.
So, my lord, this should be allowed to progress is the case. And this should not be allowed to abate. And the direction is very, direction is very alarming.
But the tribunal says proceedings are abated.
Abate and said, please see the 7. On examination of the facts and issues involved in this case, vis-a-vis the case referred to, we do not find any ground to differ from the view taken by the New Delhi bench that since applicant is well and suspicion is allowed to retire by the husband on attaining age of superannuation without any objection and without any initiation of department proceedings, the order of his suspension automatically spends its force, becomes redundant to pay.
Not there. The proceeding has come after that order. There's one fact which has to be remembered. On the date the CAT passed this order, there was no disciplinary proceeding. The charge sheet has been issued a year
not
later.
that. When were you suspended?
I was suspended in 2019 on contemplation.
The rule says the proceedings are deemed to have been instituted.
Yes.
As on the day the charge sheet is given to us.
Yes.
Listen to us.
Yes.
We may be wrong.
Yes. No.
Hear to us.
Yes.
Purport of the rule is it speaks of two things.
Yes.
Institution of department proceedings is one thing.
Yes.
Initiation of criminal proceedings is another.
Yes.
Delhi High Court is structured its judgment not on the initiation of this.
I also agree that the Delhi Judgment High Court, which is not relevant.
Because two separate rules are there.
Yes. Yes.
Even under rule 9 of old regime.
Yes.
And rule 8 of the new regime.
Yes.
The purport is same.
Yes.
But they are only split.
Yes.
Textually they are split.
Yes.
Solved.
Yes.
Except that there is no change. Number one is the Delhi High Court judgment would not have been followed.
Yes. I agree to that. I concede to that.
Because we can only say that famous judgment of Lord Halsbury, Pin versus Ledan.
Yes.
A decision is an authority for the proposition that is laid down in a given fact matrix of the case.
That is.
And not for all that which logically follows from what has been laid down.
Lordship, if your Lordship is
11 judges have approved it in our Supreme Court, Madhav of Scindia, 11 judges.
Madhav of Scindia, first case.
If I just
Listen to, you may become wiser.
Yeah, no, we always.
We should lend our ears.
Mr. Mohanty, this is 8B is also a step ahead.
Yes.
It is not speaking about the submission of charge sheet.
Yes.
It speaks about in the case of criminal proceedings,
yes,
on the date on which the complaint or report of a police officer of which magistrate takes cognizance. It is not charge sheet.
No charge, not charge.
It is complaint or the report.
Yes.
I agree also, because complaint is defined under the criminal procedure code. Even that can be.
Yes, that can be.
Or report, that will be 178.
Yes. I totally bow down to that. I have no. As a matter of fact, I'm agreeing to what Learned ASG is saying. I wanted to say one thing.
Yes.
Lordship, I had a separate set of arguments which the CAT did not consider. They have written that in their order. My argument, para 5, you just read it for my friend, it will help my friend also. We do not see any justification to deal with the line of arguments and all the pointers made by learned sources are applicant in this way.
The findings recorded is not in accordance with your argument.
What was my argument? The only thing we did not challenge it because finding was in our favor. But my arguments were not even considered. They went in a different tangent.
Do you agree for remand?
No, Lordship.
No, you're asking.
It can be remanded.
We are asking you.
It can be remanded. But if the Lordship decided, yes, it can be remanded. But if the Lordship
we are asking you. You have to resist your temptation to interfere.
Sorry, I bowed.
We are
He's
asking.
young, he's very young. We'll give it to him.
No, I'm very old. Maybe older than you.
Very experienced.
Oh, older than me. Oh, you look very young, sir. Handsome also.
He's learned also. That's another thing. See, when wise people say something,
Yes.
we should lend our ears.
Yes.
Then we can say right, wrong, etc. If we refuse to listen itself, then how?
I agree, sir.
Now we are asking you, and our question admits binary answer. We are caveating you. Do you agree for a remand? The word "you" in English includes our AST also, Mr. Venkatraman. Or you want us to decide the matter? Either way, frankly, if you say we decide this matter, there is no dispute, you only decide it, we will do that also, no issue. Whichever way.
But I will use the binary in 2 steps. First option, your lordship may decide. Second option, remand. I use the binary both ways.
I will follow what my learned says. Why I'm saying that only.
Tushar, 1 minute. But can I be permitted to leave your lordship? I have one more.
Very good. No issue. That's the only argument.
Yes. This is the only argument.
Thank you
But it's
so
a
much.
pleasure to address your lordships. Pleasure to address.
To hear you also. Thank you so much.
Thank you, Tushar. You've been very happy to argue a very fair counsel. God bless you. Thank you so much. Thank you so much.
Actually, what has happened today, 4.5 years, 4 years and few months of retirement, he's not getting a single penny. Going back to tribunal, your lordship,
Cannot be.
that is
We'll decide
the only problem.
We will decide this.
Yes, sir.
Now,
Yes, I'll address that. I'll just let us go back to what he was reading, the rule 8 of the old rules. May I read it again?
Yes. Which is our page?
My page is 351. 351.
Go to 351.
This paper was started from 79.
It's the second procedure.
Volume 3.
May I read, your lordship?
Yes.
Volume 3. Yes.
Volume 3. The departmental proceeding shall be deemed to be instituted on the date on which the statement of charge is issued to the government servant or pensioner. I pause here for a moment.
One second.
Yes.
Which page?
Explanation. Page 351, explanation which my learned ASG was reading. I'm again reading it. Yes.
The president may
Then
at any time.
we are going to, your lordship, the explanation at page 351. Explanation. For the purpose of this rule.
Yes.
May I read, your lordship?
Yes.
For the purpose of this rule, departmental proceeding shall be deemed to be instituted on the date on which the statement of charge is issued to the government servant or pensioner. I pause here for a moment. Here, deemed to be issued on the date on which the statement of charge is issued to the government servant or pensioner. Both words are there, government or pensioner. Or if the government servant has been placed in the suspension from the date of an earlier date or on such date. Here the word pensioner is missing, your lordship.
No, there is completely different.
Yes. What I'm saying, because for the pensioner, the suspension has to abate. That is why the word pensioner is missing from the second part of the sentence.
Completely should be.
Let us read it again, your lordship.
Government servant
For
or
my
pensioner.
understanding, better understanding, departmental proceeding shall be deemed to be instituted on the date on which the statement of charge is issued to the government servant or pensioner.
Or in the sentence.
Yes.
Shall be deemed to be instituted on the date on which the statement of charges is issued
To the government servant or pensioner.
or pensioner.
Here we stop. Yes. Yes.
Slowly. So a departmental proceeding can be instituted against an employee
Yes. Or a pensioner.
or a pensioner.
Pension.
Okay,
Yes.
that is first one.
That's fast.
Plain English.
Yes, plain.
And Martin English.
Yes.
Then the second part, there is comma.
Yes.
Kindly see this.
Yes.
There is comma
Or.
followed by or. Distinction.
Yes. Therefore, this is a separate. Yes.
Distinction.
Yes.
If the government servant has been placed under suspension
From an
earlier date,
for such
On
day.
such day.
Yes.
on such day,
This government servant was never given a charge sheet because he is a pensioner. He was given a charge sheet when he was a pensioner.
No.
Yes, the charge sheet is issued in 2025 for 24 to 2.5 years
No,
after.
no, there is this is disjunctive.
disjuncted. Or is there. So independently you have to read.
Yes, I'm
The
reading
first
in
part you have to forget.
I'm forgetting the first. In the second part, there is no pensioner. That's what I'm saying. Therefore, for the pensioner, it will not be from the date of initial suspension.
He was suspended
He was suspended in
on 22/11/2009.
19,
But he retired only on 31/1/2020.
22, and such charge sheet was given in 2024. That was even after the CAT judgment. Lordship, and the CAT was not aware of any disciplinary proceeding, therefore it gave a judgment accordingly. But before my lord, the charge sheet is still there. But here, the charge sheet was given as pension. Now, I take your lordships to one other rule in this, Rule 8. Rule 8.
The suspension of earlier date is only restricted to the government servant.
Yes, that's what I'm saying.
Not to the pensioner.
Yes, that's what I'm saying. Because then what was falling from my lordship would happen. Yes, sorry. Sorry. Then what will happen, your lordship, is that he'll to be deemed to be continued as the suspension, which was lordship was saying would not be possible because
Therefore, I reframed the question.
Yes.
I reframed the question on the basis of what Justice Ramajoyce also has said in some judgments.
Yes.
What I was saying was, instead of asking the question, if you ask a wrong question, wrong answer will come.
Yes.
Instead of telling whether suspension would overstay the retirement, answer is no.
No. Answer is no, and
No.
I'll show the rule also why it is no.
But question is not that simple.
Yes.
Question is whether an employee who was under suspension
Yes.
Action had already followed.
Yes.
and retires
Yes.
during the operation of suspension,
Yes.
can he claim full emoluments
Yes. I'll answer this.
or not is the
I'll
question.
answer this question, Your Lordship. Lordship may see my written arguments which is on record, which was given to the Honorable Fellow. That starts at page 93 of the written submission, volume 2.
Can we come back after?
Yes, Lordship.
Because of Lordship matter. We will settle this matter once for all.
We were in page 351, Your Lordship. Trying to, I was trying to
One
understand.
factor,
Yes.
when actually the departmental inquiry came to be instituted,
The date is, give the date, November, just give the date, Your Lordship. 1/11/24. That is annexure A6 to the writ petition.
that is subsequent to CAT order.
Yes, subsequent to CAT.
Yes.
And Lordship may just have one look that we are reading Rule 8, Your Lordship.
Correct.
I was trying to make a submissions that when it is a suspended pensioner, it does not relate back to the old date. Only if it's a government servant, that is my understanding of the rules. Your Lordship, I'll read it all over again, Your Lordship. Explanation. That page 351.
For the purpose of this rule,
Departmental proceedings shall be deemed to be instituted on the date on which the statement of charges is issued to the government servant or pensioner. Here is a comma, so it's a full sentence now. Then, or if the government servant has been placed under suspension for an earlier date, on such date. Therefore, the second part only relates to the government servant and not the pensioner. Which will also reinforce that once a person under suspension retires, demits office, he is no longer a government servant, Your Lordship. Therefore, that relationship has to cease.
no, that date may go back to a period when he was.
But the rule does not, earlier rule talks about both government servant and pensioner. The date on which the charge sheet was issued. But for the government servant, it will relate back to the year if he was under suspension. That's what it is. For the suspended or the pensioner, it does not relate back to the old date. Actually, this is a plain reading of the rules which I understand, Your Lordship. Because the second part, with the comma, they said or. Both the things are there.
Earlier date.
No, we can't say that the legislature was not, in its wisdom, it was not there. Deliberately it has been omitted. No, it is purposefully. The first sentence, if he speaks about the government servant and pensioner, then comma, then or, and it starts, which does not include pensioner. What is that?
And Your Lordship, then I'll take Your Lordship back to the same rule, sub-rule 3.
One second, we are processing. No, hold. Processing has to take place.
Sorry.
You are not reading some novel.
No.
How various high courts in the country have construed this provision?
Your Lordship.
No judgment.
No judgment. At least I know of none, Your Lordship. I did try to find out. Because it's a very new legislation to December 2021.
No, even earlier to that.
The old one also, no, there's nothing on that subject.
Do you have a Swami's compilation on pension rules?
I don't have, Your
Yeah,
Lordship.
this is the one
Okay, Swami's.
that you can sit.
Yes.
Swami.
Yes,
Okay. Yes. How any Swami has given any
interpreted.
any comment on this?
No, Your Lordship. I didn't find any. But anyway, I'll have a look at it.
No, there is one maxim in Maxwell's interpretation of state. There is also in Broom's legal maxims, which supports to some extent your version, where law uses X and Y in the first part, and in the second, only Y. Then the presumption is X is excluded.
Yes.
That is exclusio
ulterior.
ulterior
Something.
exclusio ulterior, something like that. But that's a very weak maxim. In India, America, England, Australia, that is treated as a very, very weak maxim. Therefore, we cannot put so much stress on that.
No.
1 second, just listen to us.
Yes.
It may help you.
Yes.
Your temptation may kill the argument itself,
Your Lordship.
and your case as well.
Your Lordship.
Yes. Now, question of placing a pensioner under suspension will not arise.
Yes.
It's a common sense.
Yes.
At least it's a jurisprudential sense. That sense is not offended by the lawmaker when he texted this rule. All right, that is one thing. But a pensioner can be taken to his purvashrama, that is employee, with a retrospective. Once it says that a government servant is deemed to have been suspended, means it can be a pensioner who will be deemed to be suspended as the employee. It's a language, after all. Law is language. So the intent, content, that we have to infuse in that.
Yes.
Not just by some symbols, like full stop, comma, semicolon, colon. We cannot go that way. It's not that simple. In any standard book on interpretation of statute, like Crawford, Grace, Sutherland, Maxwell, they say, while interpreting the provisions that Aharon Baron, Israel, Aharon Barak, he also says like the famous book, The Pervasive Interpretation of Law. He says, before undertaking the interpretation, first thing we have to keep in our mind is the purpose why this rule is made. Then the interpretation process begins.
Yes.
That way. Therefore, your version, that first part of the rule employs the terms government servant and pensioner, whereas the second part does not carry the thing so too far. We are interpreting a rule.
Yes.
And not the act of parliament.
My thought process was that because the relationship between the employee and the employers finishes after the superannuation, therefore the suspension that cannot be related back.
That is my interpretation of the things, Your Lordship. Because he is no longer a government employee. That is, but therefore, but if a government, he is still in service. Now, another rule which I will show, I wanted to show as to this, letter rule 8, sub rule 2, C. Just previous page, Your Lordship.
Rule 8, sub rule 2.
Sub rule 2, C.
To C.
C. Page 350. The departmental proceedings, just one page earlier, Your Lordship.
If not instituted.
C. The departmental
Proceedings, if not instituted,
instituted when the government servant
was in service,
whether before his retirement
or
or
his,
during his re-employment,
yes, Your Lordship.
shall not be instituted,
Save
with
as the sanction of the president and format. Your Lordship, this will not apply in this case because he was always a Group A employee, therefore this that did not apply.
Why?
Because he was always a Group A employee, always his president was his disciplinary authority. Therefore, it had to be done even before retirement as president, after retirement also done by the president.
Only.
Yes. This is a custom service officer, Your Lordship. Therefore, his disciplinary authority was the president. For all others, Group B, Group C, Group D, the disciplinary authority is up to the secretary level, depending on the group. And therefore, for them, it is the valid rule that the approval of the president is necessary to give a suspension, charge sheet to any officer after retirement.
Rule 8C.
See, what I'm talking about is 2 years.
Revocation of the suspension was also by president.
No, there was no revocation. He retired under suspension.
Right.
2, which is important, which I want to stress, Your Lordship,
Right.
shall not be instituted. Shall not be in respect any event which took place more than 4 years before such institution.
Before such
Institution. The date of institution, Your Lordship had asked me, I've given 1/11/2014. Let us go back to the charge sheet, Your Lordship. Now, the allegation in the charge sheet speaks about, Your Lordship, 2010 to 2014, which is 10 years earlier, more than 10 years earlier. Therefore, this charge sheet could not have been issued. The Lordship will see the articles of charge, that is annexure A6.
The articles of charge you are not challenging.
It has been
Because
separately, it has been separately challenged in an OA, Your Lordship.
Therefore, we need not go to that point.
Only I'm saying is that, therefore, I'm only pointing out validity. They are relying on a thing which could not have been given, Your Lordship. Two things about the charge sheet. One, it was issued after the CAT judgment. So the CAT could not dream that something will happen later. So it gave a judgment on the basis of what were the facts on that day. And secondly, prima facie, this charge sheet could not have been given because it's more than the 10 years.
Limitation period.
Limitation. Yes. And third, factually, the allegation is that he created Benami properties in the name of his wife and his son. Your Lordship, the last 2 annexes of my written arguments, Your Lordship, are
the question of limitation
yes, Your Lordship.
has to be read
Yes, Your Lordship.
with the deeming clause. Deemed to have been instituted.
Yes, sir.
If you are suspended, it is deemed to have been instituted.
Lordship, first of all, 3
Because they are all part of the same section.
yes,
So,
3C will come and then we'll go back to deeming. Because if you can institute, then only it will be deemed.
no. Deeming is creating a fiction.
Oh.
The effect of deeming can be nullification of a provision. If lawmaker chooses, he does it. Now, there is because of deeming. See, institution cannot be after 10 years.
Lordship.
But by the law can deem when it is deemed to have been instituted. Law says it is deemed to have been instituted when suspension order was issued. Therefore, 10-year has to be reckoned.
Yes. That can be it. That can be. But I would humbly submit that what I was submitting would be more appropriate in the sense, because this is the protection given to the government. Then what happened? It can, if you keep somebody under suspension till his retirement, you can give him after 20 years, 30 years. The basic purpose would be defeated, because there has to be a limitation to accuse somebody. Because delay in issuing a charge sheet is also a ground for quashing of the charge sheet. Lordships have held in a pattern of cases that unexplained delay would be fatal to the charge sheet. And two factual aspects, Lordship, page 407 and 810.
But I read a judgment exactly contrary to what you are saying. Apex Court
Lordship.
said exactly the contrary. Delay per se is not a ground for quashment of the proceedings. That's how they said. But they have also said somewhere that unless that is duly explained.
Unexplained delay, Your Lordship, is that. And that's Lordship, see annexure A10 and A11. These are the two orders of the adjudicating authority regarding these very Benami properties which they are spoken about in the charge sheet. And both have been rejected. You may see, they have been found in favor of the, because they said his wife is no longer alive, Your Lordship. Therefore, the question of his wife being there, the two sons, they were given to the two orders, Your Lordship. Both the things, it has been found that it is their property and not a Benami. It's not, I am taking Your Lordship to Annex 810, page 407.
Allegation was
Benami property. That you have purchased Benami property in the name of your son and your wife. This adjudication is there by the adjudicating authority that it is not Benami.
Which adjudicating authority?
The provision of Benami Properties Act, Your Lordship.
Benami Transactions Prohibition Act 1988.
Yes, Your Lordship.
Under that, there is there is an authority.
Yes.
Who decides whether it's a Benami property or not, and if he holds Benami, it will be forfeited to the government.
Yes, Your Lordship.
That authority has held.
Yes, Your Lordship.
What it has.
Annexure 810, Annexure 811.
What it has done.
I'll read out that. We hold that the following properties are attached under the subject reference are Benami properties of alleged Benami are not proven, and the inquiry proceedings and orders of the initiating officer lack statutory strength in constancy on standing on weak legal legs for reasons discussed above.
These properties were bought in which year?
These properties, Your Lordship, were brought, also they are in the charge sheet it is given. Something like.
And when the wife died?
The wife died, I'll just.
Much later.
Much later.
Yes.
Your Lordship, what? Yeah, the property that 2010, 11, 12, 13, 14. Your Lordship.
Wife died in which year?
Your Lordship must have after COVID, Your Lordship.
So then the question of your submission, you are mentioning about the death of wife.
Yes.
Makes no sense.
No, I'm not. I'm saying I only said that he's no longer, therefore it cannot be adjudicated. That's what I only say. Therefore, two sons, they were adjudicated.
But why, so far as wife is concerned?
They did not take up for adjudication. I do not know why. Because he doesn't apply, Your Lordship. Complainants apply for adjudication. They take possession and then they issue notice issued. I'm not very about these facts and
circumstances. It is also correct in saying that we have also to see the other, see 8.3. 8.3.
Yes, Your Lordship. Yes, 8.3, Your Lordship.
What is that?
3C.
In case of the government servant retiring.
In the case of government servant who has died on the program. In the case of government servant retiring, we have retired on attaining the examination or otherwise, and against whom any department of instituted or where departmental proceedings instituted under Rule 14 are continued under Sub-Rule 2. Yes. A provisional pension as provided in Sub-Rule 4 shall be sanctioned.
Yes. If he had been given before, that will continue under that rule.
No, if he retires.
Yes. If in case the government servant who has
retired,
or otherwise, on superannuation or otherwise.
Otherwise, yes, Your Lordship.
So this,
Maybe voluntary retirement.
Yes, anything, yes, Your Lordship. Then if it had been given before retirement, it will continue. He was given after it.
so what is your claim here?
Your Lordship, this charge sheet was given.
No, your
What was my claim before the OA? That's what I was coming to now with all this.
What is your
My prayer before the OA was that my suspension was bad in law. And that was never adjudicated.
because by then the disciplinary action had not
Because it-
contemplated according
No,
to you.
yes. What had happened, well, let us say again, he was suspended on the charge of contemplated disciplinary proceedings in Bombay. And he was transferred to Bhubaneswar. And therefore, I put the circulars on record, Your Lordship, to show that then he should not have been suspended.
Why?
Yes, Your Lordship, I'm taking Your Lordship to the OA, which starts at page 11 of my written submissions. They did not put the copy of the OA in the writ petition. And I will.
What is the order tribunal has made now?
Tribunal says give them his full benefits. But I did not challenge it because they did not consider my contentions, but allowed the OA in some other terms. Therefore, I had no question of challenging it. I'm getting my money. Why should I challenge it? Your Lordship, page 23, para 4.8. This is what the Vigilance Manual says, Your Lordship. May I read out, Your Lordship?
Yes.
Page 23 of my written submissions, volume 1. This is the Vigilance Manual I'm talking. Vigilance Manual, volume 1. A government servant may be placed under suspension when a disciplinary proceeding against him is contemplated. That power they have, I concede with that power, Your Lordship. I'll take Your Lordship to the next page. 6.3.3. It may be considered whether the purpose would not be served if the officer is transferred from his post. If you would like to take leave, that might be due, and if the government thinks out such steps may not be inappropriate, there should be no objection to leave being granted to him. In this case, he was transferred. The basic purpose of putting a government servant on suspension is that he should not be in a position to tamper with the evidence and the witnesses.
No, not only that. That was very basic.
Very basic.
Suppose
Not very basic.
if we know that the people will not be injustice at the hands of this man, then also we suspend.
But here,
Pending inquiry. No, we're
yes,
only saying power to suspend, which was 5 decades ago said, it's not like that now. It has so suppose he has a propensity to abuse employees, and on the ground of abuse, D is instituted. We suspend him. You mean to say merely because he is transferred to some other place, that the suspension is bad?
no, I'm not saying that. I'm saying basically this has to be considered. That's what I'm saying. Because first of all, then during his lifetime, he was never given a charge sheet till his retirement. Till his retirement for 3.5 years, he was never given a suspension. Therefore, if your charge sheet is taking so much of time, Your Lordship was talking about Ajay Chauhan Chaudhary, after 3 months anyway, the suspension should have been revoked. My basic
Reviewed.
Yes. My basic contention before the CAT was twofold. One was whether the suspension was necessary, and second, which I was arguing in the morning. Now that he has retired, whether the period of suspension should not be treated as on duty in terms of FR 54B. That was my argument. None of the arguments were taken, was considered by the tribunal.
Whether the suspension was then necessary or not.
Yes.
That was never adjudged.
They were never adjudged.
Whether matter was reserved.
Yes, it was reserved. Yes.
CIT reserved the matter, then gave it.
Yes. Had it, then I would have said something. Your Lordship, I'll just take Your Lordship again to FR 54B, which will the start FR 54B, I'm again reading, when a government servant who has been suspended is reinstated, all would have been reinstated but for his retirement, including premature retirement. While under suspension, the authority competent to do so, to order reinstatement, shall consider to make a specific order regarding pay and
That is like 54(6) something. like that.
54B, which we read, one is this, your lordship. May I have again have a look.
Then review goes to 6.
Then review goes to 6. Therefore, when a person who retires, the word very clearly, I'll again read, your lordship. When a government servant who has been suspended is reinstated, that is not applicable to me, or would have been so reinstated but for his retirement, including
how
premature.
to decide? You would have been reinstated. How we are going to decide that?
This is the rule, your lordship.
I'm just asking.
Because
How rule operates, we have to look.
yes, they say including, which means that on the date of the suspension, my reading of the rule is that on the day of retirement the suspension finishes. So that's
No,
my
they would
reading
have
of-
said that in rule itself. They would have said.
They have not said specific.
They have not said.
Yeah. But the word used again, I'll read it, including premature retirement. They are talking about this.
Because that in the paragraph 6.
Huh,
Land
that
Tribunal is
one.
dealt in the paragraph 6, 5.6. Page 57.
What, Mr. Parity, what you rejected for what purpose? Why?
That is in the tribunal's order, tribunal's order, that is page 50, that is start from page 51.
Now we'll come to that.
Yes.
Now he says, you have seen that rule, na?
Yes.
8
C plus 3.
2.
Yes.
And 8 also.
In referring the 8 subclause 1A, then 3.
No, for explanation he read, na?
Yes.
Now, how do you answer that explanation? He says, if the rule maker intended in the first part, he uses the word government servant, employee, and or pensioner. That terminology is used with truncation. Full for terminology is not used in the second part. Therefore, he says, only if the government servant means government servant in employment.
In employment. And
For him, we have said other persons are pensioners. Rule itself has said that. I am a pensioner. If I were to fall within the first part, we can understand. In the second part, pensioner has no accommodation at all in the second part of the rule. Can you read that? Do you catch what we are telling you?
Yes.
Go to explanation.
Yes.
Explanation to sub-rule 8. For the purpose of this rule, that is 21 rules. What is your answer?
That is, let's see, is referring this 1A. The department proceedings shall be deemed to be instituted. Right? Yes. Deemed to be instituted on the date on which the statement of charge is issued to the government servant or pensioner.
Stop there.
Yes.
What is meant by this?
Servant or pensioner, that means the necessary intention is that the service holder vis-a-vis the pensioner.
no.
Or means
Not
that the service holder is a one category and pension is a different category.
Against both of them, you can institute the proceedings.
Yes.
Correct? Go to the second part.
Yes.
There is a comma followed by or.
Or if the government servant has been placed under suspension from an earlier date.
On such day.
On such day.
But he is not a government servant.
He's not speaking about pensioner now.
Because first part, which brother pointed out a few minutes ago, first part speaks of a government servant or a pensioner. The second part does not speak of pensioner at all. Therefore, he says, we do not fit into second part at all. Number one. Number two, it decides when disciplinary proceedings are deemed to be instituted, or a criminal proceeding also, other part with which we are not concerned. A departmental proceeding is deemed to be instituted or commenced as on the date the charge sheet is served, charge memo is served on the delinquent employee, is the purport of this rule. That rule uses the term government servant and pensioner in the first part. In the second part, the word pensioner is conspicuously absent. Even a blind man can see that word is absent. He says, since the second part, I am a pensioner and I am not a government servant, no longer a government servant, you cannot invoke that at all against me. That is his argument.
As he requested me to give the answer tomorrow, I have told him. But my answer to that extent I am not.
No, if
Can we, I put a
don't
question
answer.
to me, my lord, can I put a question?
Don't pollute it. If your ASG is answering,
Yes.
then you do not answer unless you intend to pollute it.
Yes, yes. Sure. He requested me 2 p.m.
2 p.m. We call it tomorrow.
Lordship, I'll
Any
appear online if your Lordship will permit.
Yeah, no problem.
Because I have
Come
to go
on.
back to Delhi today.
Very good. No issue. What's to?
And
That the maxim is, I remember now, I recall now. Expressio unius exclusio ulterior.
LTC.
Just look into that also.
Yes, your Lordship, I'll do that. And one thing else I wanted to tell your Lordship relating to this case is that this same applicant had also filed one application for
Challenging institution of the proceedings.
yes, that is in High Court in CAT Delhi, your Lordship.
But one more aspect that you tell ASG. See, deeming clause is as to the date of institution of the proceedings. Okay? In other words, even if you have instituted the proceedings years after the event, the rule says, in connection with that event, if he is suspended and thereafter you have instituted the proceeding should be deemed to have been instituted not on the date when the charge memo is served on him, but on the date he has been suspended. Deeming clause. This deeming clause has something to do with the limitation clause of 10 years. With your friend, you have read it?
Yes, sir.
10 years.
4
For
years.
reckoning, 4 years. 4 years. That for reckoning that 4-year period, the commencing point is the date of suspension. Provided you had instituted the proceedings when the order was made.
Even then, your Lordship, I'll say one thing. The period they talk about is up to 31/3/2014. I was suspended in 2019. Even if it dates back
Even by 4 years, it will
yes,
be.
even if they date back to that date, it will not be valid. Even if they date it back to 2019, let us say by the deeming provision, they relate it back as illegal fiction to the date of suspension. Even then, it's beyond 4 years.
Because suspension was on 22/11/2019.
19. And the last date they have given is 31/3/2014. The period is from 10 to 31/3/2014.
Even if last date is taken, it will be beyond 4
Beyond
years.
4 years. Even then.
October was even 2019.
You may receive the government.
2019. You receive the complaint.
Complaint.
Yes.
No, that's not the point.
No.
When you receive the complaint and you will put in your drawer is irrelevant. When you issue the charge memo to him,
Is that it?
that is relevant under the rule. Let us see.
One submission. Last occasion there is a order. My lord, as far as an order 12/12/2025, wrongly I have submitted one number, but wrongly one number typed. instead of 10143 of 2025, it is written 2034 of 2025. Wrongly one I number is in it. That is, yes.
Anyway, we have traveled beyond that now.
Because
Is it relevant?
Eh?
Is it relevant? Does it amount?
Yes.
Does it
We
have
filed
an
an
I?
We have filed the I.
Does it
There is
have
the I number 119 of 2025. 26.
IA number
119 of 2026.
25?
26.
But you have written 25.
It is
119 of 2026.
Flag D.
Supported by an affidavit seeks a small rectification as to
The I number
IA number
104,143 was written.
10143 of 2025.
And this will be changed to 20345 2000.
But if the union government has filed an application in IA number
I number 119 of 2026.
2025, supported by an affidavit seeking rectification of the IA number, which is wrongly typographed as IA number 20345 of 2025 instead of IA number 10143 of 2025. First up, do you have objection? Counsel for the petitioner very fairly concedes to the same. First up, in view of that, at which paragraph of the order?
It is this first paragraph. Narasimha,
Order dated?
order dated 12/12/2025.
Therefore,
Order number 7.
registry to make necessary rectification in order number 7
Yes.
and issue a rectified copy free of cost if applied for.
Hello.
IA is called. Make it order on IA.
Tomorrow 2 p.m.
It is just also here. Item number 9. Yes, please. Yes, sir.
Item 9, WBC 14253 of 2022.
Yes, sir.
I've given a note manner to my lords. Maybe they have given what? They are not different. They have got no note. Probably this, they will, now probably they. I mean the purpose. Where's the purpose? Purpose. You can see the. Passing on through manner the fresh notes, saying sections. So the direction, the direction. Into one of the. Into the page. So that can.
Yes, Mr. Das.
Challenges to the improved order at page 69 of annexure 1(4).
What does it say?
It says that they don't regularize me, having worked.
Your prayer was for regularization.
Yes, not regularization. Really, the prayer was very peculiar. Prayer was for declaring me temporary casual.
Which is give you the cadre of temporary cases.
Yes.
Status of temporary casual.
Which really doesn't matter today. After Jacob's as well, says that in event you have worked in a perennial sort of work, and state being an ideal employer, they should not be treating you after so long like that. And similarly, circumstances, persons in the postal department have been in the meantime regularized by the tribunal also.
How many years of service you have?
I'll give you that chart, my lord. There are different people in different names, but I'll give you that chart. You will absolutely.
How many persons?
There are now, my lord, 31, my lord.
So for each one of them, there will be a separate date of appointment.
Yes, my lord. I'm giving this, my lord, for my lord's convenience. I should have made 2 pages. No, 2 papers. My profuse apologies, my lord. I should have made 2 copies, my lord. No problem, 16.
39%.
Yes, yes.
Latest is 2015.
Yes, last one.
May and Suresh survey copy of motion, it was submission today. I just took it, 2-3 days time.
Because you have given.
Copy is served earlier.
Earlier occasion also copy.
Earlier we have served a copy, man. 2000, I have no problem. My lord, I have no problem. My lord, sad part is, my lord, these people have been without employment from 2019. And my lord, what has happened, those very places, they have even now taken people.
Very same person.
No, my lord, some, four of them, and all others from outside. My lord, these are postal places where they become sorters. They run the, place
office.
everything in the post office. Then they do even, my lord, computers things. And after having used them for so long, my lord, what happens? They geographically change the place one day. And when they geographically change the place, my lord, they don't give us employment and give a fresh people. Perennial, certainly, my lord.
Mr. Party, when will you be ready?
Up to 10 days, any day.
Next week?
My lord, whichever date, my lord, any date, my lord, on when. Whichever date.
15?
15th, my lord, I have a part third, my lord, a longish part third.
Whichever date?
16th, my lord.
15 minutes. On 13th?
Yes, man.
Put it on.
I will come but 30.
15th, 15th.
16th, 17th. Oh, Lakshmi, 22nd,
On 23.
23. How many medals are posted?
1 matter.
Okay, we'll put it on 23rd.
Yes. But only specific, my lord, 2 p.m. with my.
I will accept that. I will not take that.
No, he wants at 2 p.m.
Yes.
Subject to pleasure of my lord.
But if somebody, we'll pass over. Otherwise, also we'll pass over the matter. That first.
No, my lord, if it reaches, I'll come.
Very.
My lord, I'll be online, I'll come back.
Item 12, WBC 22677 of 2025.
You already heard the matter. You can have the refresh or to file again. The petitioner agreed by the order start by
Who is your opponent?
Central Administrative Tribunal.
Who is your opponent? Same some set of people. Very good.
And what happened, my lord? The one part of the prayer has been allowed, whereas another part was declined. But the same bench have allowed another person's case, and relying that case, only allowed one part. I have already shown to your lordship. Your lordship returned the case to that the judgment. That dispute special pay and special allowance. Initially, just I will take only 2 to 3. Your lordship may kindly see the impugn order.
What was your case?
That case that after retirement, they refixed my pay, withholding that the special allowance which was granted in the 99, that you are not entitled for the same, as because we are getting initially special pay, which was renamed or retermed as a special allowance.
What is it?
The allowance that they used to get initially was termed or renamed
Same
as special allowance.
special allowance. That is in view of the
That was withdrawn.
that was withdrawn. That you are not continued for 3 months.
Withdrawn in retrospective effect.
It is retrospective.
And recovery order.
Recovery started. Recovery part to tribunal allowed, cannot be recovered.
Oh.
But restoration was rejected. Whereas the same bench allowed the case of Ganesh Kumar case. And relying Ganesh Kumar case also, this one case was passed.
Your Lordship will kindly see this order.
Did you challenge this? This is Katak's bench.
Yes, my lord. Both are the cut off bench judgment.
So it is not challenged.
Ganesh Kumar, it has been implemented.
It is implemented.
Yes.
What happened, today we received instruction. They are saying that we have.
You have preferred SLP against this.
Yes.
But you have implemented that order.
But one case is not a precedent for which written
That's
letter to
right.
More such things. He was either to
What is that?
it's not understand.
Does
They are
that
saying
make
that
sense?
Yes. That's why I need some time. 1 second, because one way they are saying that we are implementing and it's not.
Yeah, you have said that. If you are
yes.
implementing that order, implement this order has to go.
That's why.
How tribunal will have two sets of orders?
True, man. That's why I need some time because such instruction in way surprise any.
No, even in Ganesh Kumar also.
Ganesh Ram, come on.
Ganesh Kumar also.
Relief is granted.
Relief is granted as similar benefit was extended to.
Yes, that
Other.
order is also.
Others.
Yes. And Ganesh Kumar case also relying the
Yes.
other bench judgment.
13
They are
and
written-
18.
Mumbai
They are
judgment.
also-
We have all
that
and a
letter
principal
they are-
mandate.
They have mentioned about it. But point is, you have not challenged this order that Ganesh Ram
260 of 120.
Kaunath,
Who are?
No, other it has challenged and I that things I didn't about. They are written that.
See, go to statement whether this order is put to challenge. Now, how tribunal passes two sets of order on identical set of employees?
And
You did not bring it to the notice of the tribunal.
Yes. And he said, he have relied the other.
Also mentioned.
Yes.
Then what is the reason?
What reason they have signed?
They have. For what reason I cannot say. I have not discussed that. Only said that. And what happened? Ganesh Kumar case is relying the competing Bombay government and principal bench judgment. And that is also implemented. That we mentioned that you will also give 1 minute. You will also go to Bombay bench case that is at page 7.
Mr. Party, we are allowing this matter now. We are allowing this matter.
Let's make for a moment.
No.
Let's see the paragraph, internal page 4, continuing page 125 of the criminal statute.
125.
125.
You tell us the paragraph number.
Yes.
Or internal page number of the order.
It is a wrong paragraph, start from paragraph 2 onwards. But the relevant thing is internal page 4, continuing page 125. I am just reading, man. While preparing the pension papers, the accounts
Page 125.
125. Second line onwards, I am reading, man. Retired voluntary, that is on 25/1. He is retired from voluntary. 25/1/2021. While preparing the pension papers, the account showing of the department objected the fixation of the pay scale 5125 on that is on 21/3/1999 upon him promotion of the TBUP cadre, and according to the account showing, the pay of the applicant should have been fixed to 5,000 as on the date of his promotion to the TBUP.
No, that is
cadre,
the challenge
instead
now.
of 5125.
Therefore, he is here.
Well,
Why not to other employee? Only why you are singling out him?
No, madam. It is a wrong fixation of the amount.
If it is a wrong fixation, it should be a wrong fixation for other employees also. You can't be sectarian.
According to him, this Kaur is a separate cadre than this person. He is not a similar.
Ganesh, Ganesh is which cadre?
No, that is their postal department.
Postal department, all right. Cadre, which Ganesh was in which cadre?
That is a cadre.
Same cadre, my lord.
Huh?
Same cadre.
Same
What
cadre.
they have passed the account and RMC examination, but they say that they is belong to RMC.
but he passed the accounts and RMS examination. Which the means that he is the employee of RMS.
He is that case he is not BRS. He is BRS from
No, identical case.
Also from RMS.
RMS only.
Lakshmi, give me 7 days time. I will check it out and clarify the question. Even not written also.
And that is correctly fixed on view of their document.
Call on 22nd. At the request of Learned ESG Party, finally. Unnecessarily.
Item 13, WPC 25382 of 2025.
Yeah.
In this case, what happened? They have given a para instrument, it is some paragraph has hundreds of mistake. So I had asked the officer to give a corrected in. Well, fine by
22nd. 22nd.
Little more time.
Your Honor, please glance the order passed by this honorable.
No, you brought from
Last
Parawai.
is my blunt friend by the field. Given the absence, I concede to that. Only 10 days time, sir.
10 days.
That's enough, sir. You lady judge the director, you don't know yet. Drafted just like it.
On 23rd we'll have.
Can you 29th of
29th. All right. 29th. Yes. In the same order, at the request of body, finally.
Item 14, WPC 28552 of 2025.
Made.
Yes.
This case, I am challenging the
Just a minute, today we are filing an affidavit on behalf of the Archive Survey of India. But main contestant is the UPSC.
UPSC.
already sir counter they have filed already sir.
You are not, your pension authority.
UPSC is a separate council.
Yes, my lord. Yes, my lord. I am on behalf of the OP number 3 and 4, Union Public Service Commission. I have already filed the
I have a
counter.
copy of this image. What counter they have filed?
You share a copy of counter with DSG. Your counter, he should know.
Yes,
He is
I
also-
have- I have supplied to the council of the petitioner.
No, you have to supply to all council. Everybody
Yes, my
should
lord.
know what the case of other side.
Yes, my lord. On the next date, I will supply. In between, I will supply.
The recruitment will be,
29th. 29th, yeah.
Yes.
Yes. Yes.
Item 50, WPC 32352 of 2025.
Your Lord, so can you see order dated 26/11/2025, and
It is a regularization matter. We have to file counter matter.
This. It came from a CAT.
Yes, yes.
What is the counter? You can find the counter. Whatever papers are there, where there in the CAT.
That copy also not to give.
You give full copy. Yes.
I will ask the department, they will provide everything.
Why he will give, otherwise
Yes,
the
yes,
case
it is
will go
better
on
to
like
use.
this only. How many years of service?
well, since 1991, well.
91. Mr. Padi. 91. Jago.
Jago. Yes.
You also judge.
What is there? Why you take time on this? We are working this.
What 91? So I'm just clarifying what happening. Postal department is two categories. One is persons are coming under the not a civil servant category. They are EDEPM, extra department postal. They are not civil servant, but there is a different rules frame scheme made by the government of India to observing. Some postmaster post is there, but they are not civil servant. They are coming under the category EDEPM. And from the EDEPM to they are regularized as a regular. Like this, there is a two slabs. So this person who has a no sanction post, but they are engaging EDEPM, or sometimes they are the messengers. So sometimes they are some postmaster, whatever post they are holding, they are claiming regulation, which is not neither sanction post nor it was.
No, but you are continuing with them since for years.
They are continuing. EDEPM post, there is no problem.
Then
EDEPM ports, there is no problem if there's post offices continuing. Suppose post office in the village level, they are engaging the EDEPM, they are working there. The day there is continuous of post office, their working is there. The day it was closed, their service will be closed. Like this, the system is.
91 he has been working.
But here
1991.
but here is a case, he is regularized and is claiming seniority. So that's why the Jaguar case and other cases is sometimes not applicable to some of the applicants. This is the issue.
So did
Here
you
is
file
the case, he is regularized, he is claiming his seniority.
seniority?
Yes, ma'am. Yes.
It's not a case of regulation.
No, they have the earlier as per Annexure 1, the CAT is directed to regulate the services of the petitioner. Well, they have not regularized me, and instead of regularizing, they have appointed me in the forest cum water post, my lord. That is a part-time post, my lord. But so far as the direction of the Honorable CAT is concerned,
Regulation that remains unimplemented.
yes, my lord, that not been implemented.
So you went to
Again, my lord, they have not implemented partly. Again, I have approached the Central Administrative Tribunal, my lord. But the Central Administrative Tribunal passed an order referring another case of another employee, and they said that yes, my lord, that is a wrong case, my lord, that has been forcibly applied to me.
whether they filed the counter there. What is it called? Is it called statement of objections or counter in your state?
Counter.
Counter.
There also filing counter.
Whether counter was filed in this case?
I didn't have any instruction, that's why.
No.
Because the postal department.
My lord,
But they filed.
another advocate is there, my lord. I have only the OA. I have filed the original application, copy of the original application here also in the memo.
Just give me 2 weeks time. In the meanwhile, I'll ask.
On 29th will happen.
Learn more.
First week of May.
Yes.
Which some date? First of 5th of May. Yes. 5th of May.
Yes, probably.
Get the request of party finally. Yeah, wherever you have written finally, again no time will be granted.
Yes, yes, ma'am. I'll try to do it.
Item 16, WBC 3455 of 2025.
Yeah, please.
Lordship, kindly see order dated 24/2/26. The Lordship direction is there. So may read out the order.
Fresh police notice.
Yes. And thereafter compliance report.
Whether it is served on them.
Yes, it is. We have filed the requisites.
No, you have filed the requisite, but is it?
Whether they are served. Who appears for the
Compliance report is yet to be filed.
for opinion for
Opinion number 2, ma'am.
opinion number 2? Why you did not appear earlier?
In fact, the actual counsel who has been engaged by opinion number 2, he has met an accident and his fibula bone has been fractured, my lord. That's why subsequently he has engaged me to appear.
Are you ready in the matter now?
My lord, a counter has been filed.
Counter has been filed. What you have said?
An affidavit has been filed, but the copy has not been served upon me.
No, who should comply with the order?
In fact, my lord, I am for the opposite party 1 bank, my lord.
Huh?
I am for the opposite party number 1 bank.
Huh.
Well, in fact, the borrower, my lord, died. And the petitioner is the brother of the borrower who is the mortgager, my lord. And
his property is mortgaged.
His property is mortgaged along with the borrower, my lord. Or there are, my lord, the borrower, main borrower, and the other 3 are the guarantors. All of them, my lord, they have mortgaged their property, my lord. Now, in the meantime,
separate properties.
One property, but all of them are the co-sharers.
In that,
my lord. And in the meantime, what happened, my lord? The main borrower died. The loan was insured. Immediately, the bank, my lord, lodged a claim to
let us see. What are the foundational facts of
My lord, the issue here, my lord, that while after, my lord, availing the loan, the dead loanee, my lord, made an insurance coverage in the against the loan.
Loan is insured.
Yes. Thereafter, after the death, when we intimated the bank that the loanee died, they started recovery from his own account, dead man account. Then, my lord, the insurance which is, my lord, made for rupees 50 lakhs, that has not been adjusted to the loan. In the meantime, my lord, just 3 to 4 months.
50 lakhs are paid.
50 lakhs.
The insurance is paid. Insurance money is remitted.
No, they are not doing that. Is why your lordship have issued notice.
You appear for the insurance company. Who appear?
Friend is appearing.
Why are you? Why are you not paying the insurance
No, my
money?
lord. In fact, what has happened, my lord, I will, if your lordship desires, I will file a counter to that effect.
Why I desire? If you want, you file. We don't desire anything except doing justice to the citizens.
My lord, in fact, what has happened, my lord, the risk coverage is from 18.4, your lordship, 18.4.25. 18.4.24, your lordship.
You don't want to file counter now?
I want to file counter, but my learned senior has filed a affidavit and a copy of the same.
Bank has filed the
Bank has filed.
reply.
What the bank says?
Well, immediately after the death of the borrower, when it was intimated to the bank lodged claim before the insurance company. But till that claim has not been settled.
That claim is not settled.
No, my lord. In fact, what has happened, my lord, we were willing to settle, my lord, and even the bank is ready. But the dispute is that, my lord, my learned senior is claiming his death occurred in 12th month, but actually the death, as per calculation from risk coverage, it has occurred on 14th month. So he is liable to be liable for a payment of 35 lakhs 25,000, which my learned senior is stating at 37 lakhs 75,000, my lord. That is the dispute. And
no, what is the amount according to you? What is the amount payable?
Your lordship, may kindly have a glance.
No, not knowing. We are asking you.
Again,
what is the amount according to you? What is the amount payable by your client?
As per 14th month, my lord, it is 35 lakhs 25,000.
That amount, why you did not pay?
No, my lord. In fact, we even steps were taken for.
You pay it first. First you remit that money. Next date.
By next date. In fact, it was supposed to be remitted, but as because the writ was filed and notice was issued, therefore that
writ was filed means he cannot wait till you make payment.
No, my lord. Already NPF was issued, my lord.
No, let's say 35 lakhs. What is the amount payable? 35 lakhs.
On 14th month itself, it comes to 35 lakhs 25,000, man.
For their latches, I will pay, my lord, I will get the lowest.
First you get this money. Even that you will not get.
As your lord.
But if learned counsel appearing for the insurance company, OP number 2, having argued the matter for some time, now very fairly submits that the undisputed sum of rupees 35 lakh 25,000 shall be remitted by his client to the loan account of the petitioner with the OP number
1.
OP number 1 within 3 days.
Within 1 week.
Within 1 week. 1 week. First up, to facilitate compliance of this undertaking, he seeks a short accommodation. First, accommodation granted. Call this matter on 22nd for complying with the undertaking. In the meanwhile, first time, the compliance would not foreclose any arguments of any of the parties. Okay. 20 for reporting.
May I submit one thing, my lord? My friend is referring to a schedule of.
You get first this money,
yes.
Then rest of the things. You have kept all arguments open now. What kind of advocacy?
May I pray only one thing, my lord? Instead of 22, it may be posted on 24th, your lordship.
24th?
My lord, my sister's marriage is there.
Is it? But you have not called us at all. How to believe? We'll have it on 29th. We'll have. Yes. It is fairly, he said. So much amount is paid. Yes.
Item 17, WPC 4060/2026.
Please, my lords.
Yeah.
Lords, I have not been able to comply with your lordship's order of deposit of the 12.5 crores, lordships. So, my lords, I prefer to argue the matter on merits on a date. My lords, I prepare the propositions because interim order was conditional to my payment, lordships. I had paid 5 crores, but I could not pay the 12.5 crores on the date and lordship indulged me. So Lordship may provide me a date any day, Lordship, so that I will go on the
30th.
May I,
Please, Lordship.
may I submit, Millets?
You are for the OL.
I am for the liquidator, Millets. Millets, your lordships will see your lordship's order. I am just placing your lordship's order of 25th February 2026.
Yes.
Para 2, Learned Counsel for petitioners submit that the subject security property has been auctioned for a sum of rupees 32.6 crores only on 9th of February 26, and that his clients are ready and willing to retain the property after making the said payment. He also expresses willingness to pay the solatium to the auction buyer if there is such an arrangement. However, this plea can be considered only if the auction buyer is also arrayed as a party to the proceedings.
Yes.
Then, Millets.
Have they arrayed the auction?
Yes, my lord.
Yes, that has happened. Para 3. Learned Counsel for the liquidator submits that auction having already been accomplished and the auction proceeds being more than 60% of the reserve price. Already letter of intent has been issued to the auction buyer on 10/2/26. He may make the payment within the period specified as per the liquidation regulations. He also tells us about WPC such and such disposed of by a coordinate bench with a order dated such and such. There also, Millets, similar attempt was made. Your lordships relegated him to approach the NCLT because that is where the liquidation proceedings are pending. He opposes granting of any.
No, you oppose even granting of time also.
No, Millets, I'm not on that. Millets, may I just indicate? May I just place? I'm just placing your lordship's orders. The daily orders.
Last time also, my lord, same submissions were made.
Millets, may I make this submission, Millets?
It's my
I am placing my lord's own order, which are peremptory in nature. This order reads, Millets, having heard learned counsel appearing for the parties and having turned the pages of paper book, we are inclined to grant some reprieve to the petitioner inasmuch as they have agreed with the proposal of this court to show their bona fide by depositing a sum of rupees 5 crores only on or before 27/2/26. That is complied.
And another sum.
And another sum of 12 crores on or before 7th March. Today we are on 7th April. This is not complied. And the auction amount, Millets, was 32 crores. In the registry as of this court, as mentioned over, they're ready and willing to give some solatium. Then, Millets, your lordships, in the above circumstances, the petitioners are directed to array the auction buyer as OP number 3 right now, whose particulars have been furnished recently from the liquidator's side. Petitioners have to make deposit of the agreed sums of money in the registry as undertaken. Further steps.
Failure to comply with the undertaking is your submission.
Yes, and
That
then, Millets.
Entail, it is not entitled.
Then, Millets will see your lordship's next order.
Yes.
Kindly see your lordship's next order of 11th March 26. Again,
to comply with the undertaking would.
Millets, the last para. In the above circumstances, the application in IA, this is, Millets, an extension that they sought. An extension was granted till 31st March. Extension is granted subject to condition that petitioner shall deposit additional 50 lakhs. It is made clear if the benefit of this extension is not availed, petition itself will be dismissed on the next date of hearing. It is further made clear that in that event, the amount deposited, that is 5 crores, shall go to the account of the official liquidator. Because these are peremptory orders, your lordships have clearly indicated that if the amount is not complied, then Millets, it will be dismissed. That is,
we'll follow that. It binds us also. But we'll do it the next day. That's all.
Millets,
even adjournments also you will oppose.
Millets, I am there. Millets, I am there to.
You are right.
Here, Millets will kindly take this. Kindly take this list of dates. Millets, it has been, Millets, the facet of this particular petitioner where they have been interfering with the insolvency process.
Now you have deposited 5 crore with you.
No, it is deposited with the registry.
That will go to you now.
Very well. If it gets deposited,
because he's insisting.
It's an order.
This
order. You have obtained that. You have got that order.
I am just on one thing, lordships. They extended a loan of 40 crores.
Correct.
They recovered 37 crores, and 5 crores included would become 42. 2023, they accept my notice of 20 crores. Then they immediately in 2026, they raised it to 123 crores.
Kindly read the order.
I have gone through lordships.
Yes, come on.
I am only requesting one thing, as because interim order was conditional to these merits.
No,
let us put it on 30th merits.
We will not do anything.
We'll go on merits merits.
How we have ordered the order, which is our order we have to follow. That money should go to the OL because we have said that.
may I just intervene? My lords, at least till the disposal of the writ petition, my lords may protect that also. But I'm with my friend. But I have filed an application of intervention.
Yes. Who are you?
Sir, I am actually the person who has supported the petitioner for depositing that 5 crores.
How you are concerned? It's your arrangement.
Yes, I have supported it. That I have exactly said that word. But what I beg to submit, but if your lordship permit me, I can speak.
Who can prevent Mr. Mishra from speaking actually? We can speak, no problem.
Paragraph my friend read. Let's we kindly look at that paragraph. What is the intention your lordship passed that order? But
who are you?
I'm just assisting your lordship.
What is that assistant? Some person coming from KR market and assisting it.
No, that's the reason it's not.
Mishra, you are always graceful, we agree.
Sir.
But gracefulness of a person is one thing. Locus standi is another.
Sir, exactly.
Where is the locus standi? It's an arrangement between you and Mr. Meheru's client.
Sir,
how?
I supported him.
No, you may support, you may attend marriage, etc.
I wanted to stand by
you enter the matrimonial proceedings, pray of the matrimonial. Can any person say, no, we went to their marriage and therefore we should be permitted to say on the divorce proceedings?
Your lordship, can I just read that last paragraph?
Read, no problem.
To assist your lordship. If you can look at the tenure of the order that has been passed. My friend was also saying the same thing.
Yeah.
It says in the above circumstances, because that previous paragraph says you pay the balance amount. In the above circumstances, the application in IA 4631 of 26 having been favored, extension is granted till 31/3/2026. This for deposit of 12 crores. Kindly keep it in mind. Subject to the condition the petitioner deposit 50 lakhs. It is made clear 50 lakhs have been deposited.
No, 50 lakhs not.
No, that is not deposited.
No, not deposited.
Only 5.
I'm sorry. Extremely sorry, man. But it's made clear that if the benefit of this extension is not availed, petition itself will be dismissed on the next date of hearing.
Correct.
Quite clear. If the benefit of extension is not availed, it is further made clear that in the amount in that event, the amount deposited shall go to the account of official liquidator.
Right.
But in the event that deposit that 12 crores plus 5 crores, the entire amount, it will go to the official liquidator.
Right.
So this 5 crores has been kept as a security.
No, now it will go.
So that's exactly my point.
Mr. Mishra,
so just one point. Official liquidator has already got that 32.5 crores.
No.
He has got it. That is his grievance. Therefore, he is raising the voice.
May I just say one small sentence? When this application was moved for the first time on 25th February, which Millards appealed to your lordship's judicial conscience, passing the first interim order, submission was made. The entire 32.61 crores will be paid within 7 days from 25th February. And today, Millards, we are on 7th of April.
Actually, I couldn't express myself. That amount which has been, the property has been put to auction purchases to deposit the entire amount before the official liquidator. Am I clever? So that amount is secured.
The question is not that. Order says this. Your orders bind us.
My lord, to save the time of the honorable court, my lord, may keep it on some day.
The courts also.
So that is the reason why I have also filed an application for clarification.
No, you will not hear you.
My lords, may keep it on 30th, my lords. I'll take my chance with my merits of my matter, lordships.
No, question is, Mr. Meru. Two orders say.
My lords, I understand.
The next date it will be dismissed. Still, therefore, otherwise he'll mistake me.
But the merits, the prayer of my writ petition will be knocked out.
No, that's what. That happens because of the parity.
Partly I had complied, my lords. Partly I had complied. I put in my lords.
Compliance plus
and the rest part I could not, lordship. At least my merit turn deserved to be thrown out because I could not pay the other part, lordship. Because I had challenged the auction. I was challenged. The basic my challenge the auction.
Kindly come to.
My lords, I'll go to.
Millards, on merits when they argued.
Just my lords.
On merits when they argued, Millards.
Millards, there is 2 minutes, lordship. I'll come to the order.
In identical factual circumstances, this petitioner's own writ petition has been dismissed by this honorable court.
Let me argue my matter, my lords.
Twice.
In the order for liquidation, my lords, I will take lordship directly to it. But I'll come to the things on merit, but like lordship, I'll take directly to page 149, lordships.
Mr. Meru,
please, lords.
There are 2 orders that stay read.
Please, lords.
They will not permit.
But it's my injustice to the petitioner, lordships.
Unless you make an application to recall these orders, these orders will operate as against the judges also. Res judicata is not only.
Then my lord, file application to modify this order, lords.
No,
I will
you
not
know.
file application, recall my lord, but I will file application to modify
We'll call
this
it
order.
tomorrow. Tomorrow we'll call this matter. Tomorrow we'll call.
Please,
this.
lordship.
So can you also look at the
No,
draft?
Mr. Mishra, who is your client?
Because I-
What is locus standi?
Just permit me to assist your lordship.
Hello, we don't see. It is like saying we want to assist you in your marriage. Even when the parties who are going for the wedlock are not willing.
Your lordship asked me the other day, exercising power under Article 226, 227 is wider power.
Correct.
That power has also been, I got that decision your lordship is referring to that day, but I've got it, my lord. Your lordship has a wide power to.
Wide powers all right. What is your right?
So my right is to assist your lordship to arrive at a just decision in the matter.
And in exercise of that power, we may request you.
Right.
Mr. Mishra has to.
Let's say assist your lordship.
That even
On the date of hearing, let me be there along with you.
You are most welcome to be here.
Not
Who
being
can
an
prevent you?
Not being an internal senior advocate.
My request,
as in amicus.
let my application be kept pending, your lordship will hear the matter.
I just have a small prayer.
Tomorrow I will file application modification. my lord.
This is,
It will
I just
go
wanted
on
to
with it.
bring it to your lordship's notice. Identical prayers made in a previous writ petition. This is an order by a division bench of this honorable court, where my Lord Justice Dash was also there. It is 5/9/2024 order. It says the petitioners have filed this writ petition with a prayer to direct the opposite parties to consider OTS proposal as per letter such and such to allow. It's a detailed order. Then it says, since one authority is in session over the matter, an interim application has been filed seeking some relief, and the petitioners can very well file an advance petition to move such application. We are not inclined to pass any order. We are not expressing any view on the prayer made by the petitioners in the interim application. Writ petition stands disposed. Basically relegating them to the NCLT. I didn't read the entire order, in the interest of saving time, but your lordships observe that the matter is in section before the honorable NCLT.
We will call this matter tomorrow.
I will permit you just to speak a few lines.
Who are you?
I am the OP number 3, the successful auction partner. I have been added as a party to the writ petition.
You are implemented.
Pursuant to your lordship's last direction, minutes, especially paragraph number 3 of 11/3/2026 order, minutes, I am filing a small affidavit, minutes, wherein your lordship had posed me a query, minutes, as to what would be my expectation, minutes, in case they are able to redeem the property.
No, that question will not now arise at all.
But I am filing my affidavit. I prepare along with my wakalat number.
You have to file it in the registry.
I'm filing.
But you serve a copy on the other side.
Not
Your lordship, kindly have a look at the draft, my lord. Just 1 second, my lord. Kindly have a look at the draft. This Albotech industry, they have purchased and filed it.
5 crore draft. We have seen it, no? We'll be happy if that was shared with us.
I just part on to your lordship. Your lordship will give it tomorrow. I'll be there with you.
And the bank would be happier still.
If he gets that money. Anyway, we'll have it tomorrow. Day after we have, tomorrow we have already posted many matters.
Day after tomorrow.
Day after.
Well, it's can it be in 10th, lordship, because tomorrow and day after I'm a bit tied up, my lords. Municipal corporation on footpath policy being Supreme Court, lordships.
You are going back to.
I'm going back, lordships.
On 10th?
10th, man. I'll physically be present before lordships. And I'll take some time to prepare and address your lordships on my last breath of the matter, lordships.
All right. 10th morning we'll see. All of course. 10th we'll have. All right.
Okay. Only would your lordships indicate that the interim order stands vacated?
No indication. All on 10th at the request of learned counsel appearing for the petitioner and also the senior advocate Mishra appearing for the applicant seeking impleadment. Impleading applicant. Yeah.
So grateful.
Plus, I filed that date chart for your lordship's convenience. That may be taken on record.
Very. You have filed it now.
I just handed over. If it could be placed on your lordship's brief, just for your convenience. It was returned. I'm sorry. It was.
No, it's here. It's here.
Item 18, Read Appeal 1907 of 2024.
In fact, there is an exchange of two affidavits among for the party. We'll file it in the registry. My pray may be taken up next week anytime.
Next week. What do you say? Call next week at the request of the Net Council appealing for the petitioner. And with the consent of, with no objection from the council representing the banker.
He is for the banker, I am
bank.
Yeah, so we commencing 20th minutes.
25.
20th minutes any date, Lord.
Let's say later 21st, my lord, it will be.
All on 21st.
21st.
On 21st. Yes.
Item 19, date April 3071 of 2024.
No, on behalf of Mr. Das Miller, advocate for the appellant, he has some personal difficulty next week.
We got to next. With the request of. Yes.
Item 20 has been adjourned. Item 21, date April 1235 of 2025.
Yes, may I pay my loss?
Yes.
This matter be taken on 21st.
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 Whether any astrologer has said 21st is a good day.
No, my loss, no, my loss.
And 29th will have.
29?
Ah.
Yes, that 2 of.
It will come, but that they just mentioned. Seek Passover. Or otherwise also will pass over. We'll have it. Let us.
Okay.
Next. One matter was being mentioned. Who mentioned? I don't know. Mr. Panda mentioned saying that contempt matter is there. You have to take one.
It is in weekly list or something.
That are already accommodated and already taken off. Disposed of.
Item 20 any date fixed?
Which one?
Item 21.
21, your friend needed some accommodation. You also were very happy with that.
29.
Take up.
Working list item 1, date April 2530 of 2024.
Pardon, my lord. Passover for that day.
What Passover? It is now already 3:20. 2 weeks at the request of. Yes.
Item 2, date April 3037 of 2024.
Your lordship, praying for a Passover, lordship.
Same order.
There is some time.
Next.
Item 3, date April 3141 of 2024.
3. Darcy is appearing in this. What is this matter? Staff Selection Commission. Who is the lawyer? We got to next.
No, other matter. I had one item 19, I could not reach.
19?
I requested my friend.
You have given some.
I have requested my friend to get it.
Okay. You sit down. You came running. Sit down. Yes. In 3, Mr. Dashi is in 3 also.
3 and there, my lord, Mr. It is filed by the Staff Selection Commission.
Correct.
Mr. Swine is there, Mr. Senior Counsel.
Yes, sir.
Same order. Passover. You will adjourn it by 2 weeks. Next week you do that.
Next week. Let it in that list, my lord. It will maintain its position.
The same list.
It will position the matter.
Okay. Then.
Item 4, date April 3182 of 2024.
Yes, Mr. G, what is this matter?
It's a matter relating to
Rafiq Masi.
my lord. But Rafiq Masi is not applicable to this case because Rafiq Masi is applicable to class 3 and class 4 employees. Whereas this respondent is.
But there is one more judgment which Rafiq Masi principle is extended to other category of people also.
No.
Sahu.
Sahu.
Correct.
Jogeshwar Sahu. But that is his head clerk.
He was a
head clerk.
C in our group D.
Group
Apex
C.
Court extended it to other categories of people also.
Jogeshwar Sahu.
Jogeshwar Sahu.
Jogeshwar Sahu versus State of Odisha.
Odisha.
But here, my lord, Lordship may kindly have a look to the order passed.
Who is your opponent? Did it come first time or
No,
after post notice?
Notice was issued. Notice was issued since 8/9/2025.
Notice is served on them. The opposite parties. Not here. Malti is not here.
Mr. Mahanti. Let it come. Yes, let it come. Subran.
But that Jogeshwara Sahu also just you look into, that goes against you.
Yes, but there are also some other judgments which stands in my favor.
Is it?
Chandi Prasad Sanyal and some other judgments.
But Jogeshwar Sahu is the latest judge.
Latest one.
Just looking. Call up to 2 weeks to enable counsel for the respondent to come and talk to you. Yes.
Item 5, need appeal.
Because many matters are posted. Yes.
Item 5, 3330 of 2024.
May I plead to Lordship? I pray for an Passover, my lord.
Passover. Yes.
Item 6, need appeal 514 of 2025.
Yeah.
Because the respondents are not here.
Respondents are not here. Same order. To enable counsel for the respondent to come and talk. Yeah.
Item 7, read appeal 931 of 2025.
May I please? Yeah. Yes, sir, Mr. What is the matter about?
This is arises out of the selection of Hon'Ble worker. This petitioner prepared an appeal against the selection because the person who has been selected, that is the respondent of 4, didn't produce the records as per the requirement of the advertisement. That was my ground of challenge.
Your appointment is quashed.
No, not my appointment. Just I'm saying, the opposite party was selected. I was an applicant. Along with this opposite respondent number 4. Her selection was accepted and she was given an appointment. That, as per their guideline, my lord, I filed an appeal before the learned ADN. On the grounds that as per the requirement, there are certain documents, all the documents have to be produced in a manner that she has not produced. Learned appellate court accepted my submission and her appointment was set aside and directed for, because I am the next candidate for a selection. Against that order, my lord, now government has come with a new guideline. In the meantime, after this order was passed, before the order was passed by the first appellate authority, a second appellate authority was created. RDC became the second appellate authority by a government notification on 15/3/2023. This order was passed in 24. So, she filed an challenge that order before this order
was filed.
No second appeal filed. Directly filed it here before the Honorable Single Judge. The Honorable Single Judge.
Who is that liar?
He's not.
Normally he appear in this basis, so I thought he will come. Mr. K.P. Misra, he is the senior counsel.
K.P. Misra is not here. You want to remand that matter to the second appellate authority.
When she filed the writ petition, I raised the prelim objection that this is not matter. This could go to the second appellate authority because the same learned judge of this Honorable Court has passed in another order in another writ petition directing for a second appeal. But Honorable Court here says no second appeal is not acceptable. I will hear it. And finally, set aside the order, first appellate order. That is why I am.
That was in your favor.
No, not against
the order that is set aside.
Yes,
was in
my favor. That was the. But if the one merit also, I stood by my grounds, my lord, before the first appellate authority.
That she has not produced all the
application form.
The requisite documents were not produced
in the manner prescribed.
In the manner
prescribed in the
timeline or what?
Yes.
In In the
This is the-
timeline.
Yes.
What is
Within
the
time-
explanation offered? Why they were not filed in time?
She said that this is, I, at the time of scrutiny, I filed it, so it is acceptable. And the honorable single judge
In two matters, we have held like that after following the apex petition.
and other document, what she has not filed also, not filed even. That survey report is a required document. The honorable court has said no, and the giant inquiry, they found that this is not required. So that. Yeah. Oh, yes, yes.
Huh?
This is
For the petitioner.
No, Your Lordship. Is it better?
May I place
OP number?
4.
4.
This is the contesting.
Yes.
You are the contesting party. Yes, in time you had not produced the documents is one thing. Second contention, extreme contention is you have not produced the document at all. Now what do you say? You came running.
Shall I place the finding? Let
no.
we'll settle.
We'll have it some other day. But all the way that.
Not only that finding of the
That's
first
okay.
appellate authority, I just want to read out. If my lord want. That finding of the first appellate authority, that documents he has not produced, that part.
Now, you have a second appeal.
Your Lordship, actually, I'm seeking for a, I'm seeking.
Our senior will conduct.
Senior will come and argue. Nothing. Call in the. Call on 29th. Call. How many matters posted on 29th?
5 matters.
5 matters posted. Yes. Yes, sir.
Item 4.
Item 4.
I'm the respondent.
But the petitioner was not here.
The state is
The petitioner was here, you were not here. Some date we have put.
very short.
Correct, but where is your friend?
State respondent.
State.
This is that Rafiq Masi or not.
Rafiq Masi.
That one.
Yogendra Sahu.
Yogeshwar Sahu.
Yogeshwar Sahu.
Lordship. Yes, Lordship said that it is also extended to.
Recall that one. Yes.
It was extended to my lord. But the judgment what I am placing, my lord, it is said that in Yogeshwar Sahu's case, my lord, this Yogeshwar Sahu was working as a stenographer grade 1.
Correct.
In the district judge court, my lord. There, my lord, their lordship said, however, in the meanwhile, the appellants have retired in the year 2020. It is also an admitted position that appellants were not afforded any opportunity of hearing before issuing the order of recovery. The appellants, having superannuated on a ministerial post of stenographer, were admittedly not holding any gazetted post as such, applying the principle enunciated by this court in the above quoted judgment, the recovery found unsustainable. But here is a case, my lord. Here he is a gazetted, holding a gazetted post. He is a professor. Class 1 post he is holding. So this judgment is not applicable.
No, if he is professor, it is not applicable. These are only
Class 3, Class 4.
lower rung of service.
Class 3, Class 4.
I am. Yesterday I got a good document. So they have calculated the leave in the impugned order, my lord. Page 51, the director has calculated. So earlier, since 2002, my service condition and leave rule was governed under Orissa Education Leave of Teachers of other members of staff of aided educational institution, Rule Status 77. So wherein maximum leave was 240 days. So they have calculated that they are giving me the benefit for 240 days. But the period of leave granted in my favor, 36 days. Now they are treating it as EOL, extended leave, without pay.
EL is earned leave.
On leave. On leave.
It is not earned leave.
It is LOP, loss of pay.
36 days, they are considering it at EOL.
Extraordinary leave.
EOL, not EL.
No, not EL. External leave.
But when I said EL,
yes. EL, so now my lord, external leave 30 days. So for the 30 days salary, so it is calculated 98,000. So they have deducted it from the gratuity.
So, well, presently it is revised. The maximum 240 days is revised up to 300 days. If the leave is beyond 300 days, then it will be EOL. So, well,
Sorry.
so it is not taken care of.
Yes, sir.
Well,
They have taken 240 days
Yes,
into
ma'am.
account, not 300.
not 300.
They
This
have
is
to
what
have taken 300.
Simple point.
If 300 is taken, to
Then-
that extent amount is reduced.
Yes, my lord. So my shortfall 36 days. So if it's 60 days, yes, it will be setting this point.
Mr. G, what do you say about that? No, because rule is amended. If rule, what we can do is, you will remit this matter
To the
to
authority.
the authority where you can furnish all these things
My lord.
and get the matter settled.
Yes, my lord. So here, my lord, if power is given a bold letter while sanctioning leave exceeding 300 days, prior permission of the department will be sought for. So mine is not exceeding 300 days. So 240 plus 36.
They need not have to go for it.
Yes, my lord.
Yes. They can
It
do
is
it
less
by
than
themselves.
300. Less than 300.
So they
Yes,
can
less
do it
than
by themselves.
less than 300. So
That director
admission-
Lordship has handed to the director higher
Consent
education
order,
for that.
consent order we can make.
my
Consent order will make, you will make representation to the government in the light of this new rule. Your claim should be processed.
my lord.
Till then, you should not effect any recovery.
Yes.
My lord.
All right.
Recovery.
Any recovery is ordered? No.
So yes, my lord. So there my gratuity to withheld.
But that will
19,000.
happen subject to, that will, what should happen to the withheld gratuity will depend upon the order
outcome
to
of
be
the-
made by the authority.
Outcome decision of the government. Yes, my lord. Yes.
The state is in appeal, in intra-court appeal for laying a challenge to a learned single judge's order dated 29 to 2024, whereby respondent employees WPC number 13599 of 2018 having been favored. Recovery request.
Recovery, my lord.
The recovery of excess amount allegedly paid has been passed in the light of Apex Court decision in Rafiq Masi and Ahmed Begir. It's my two. First, after service of notice, the respondent employee has entered appearance to his counsel. First, next paragraph. Both the sides having argued the matter for some time, very graciously agree with the suggestion of this court that in view of the amendment to the 1977 leave rules of Education Department,
Aided education.
Aided Education Department, leave rules applicable to aided educational institutions, the encashment of earned leave is extended, enhanced to 300 days,
300.
which was earlier 240.
240.
240. And therefore, the respondent employee should make an appropriate representation to the jurisdictional authority for granting the same benefit. So that the encashment value can be taken into account while deciding the amount to be recovered or not. First up, in that connection, all contentions are to be kept open. First up. Next part, in the above circumstances, this writ appeal is accordingly disposed of. First up, the claim of the respondent employee shall be considered within an outer limit of 6 weeks from the date he makes the same. First off, all contentions in that regard are kept open. All.
I want to make a mention, item number 6 actually.
6. Yes.
May be taken up, but the other side I have to inform.
No, by this time you are there.
In our court, only one side people will come. And subsequently, other side will come. After ensuring the one side has left.
May I pray the same to be taken up tomorrow? I will be informing him.
All that we have kept it as it is. Wait. No, weekly list, we are not making any order. Nah? We are keeping it as it is. Next.
Item 8.
Kindly pass over on the.
My lords, item 8, my lords, I have an intervention application 4910 of 2026, my lords.
Who are you?
My lords, I have been allotted that land which is under dispute, my lords, against which a lease was cancelled. So 50% of that has been allotted to me. I am one of those people waiting in the queue for the last 20 years because I'm a sawmill owner which needed rehabilitation as per certain environmental clearances and orders of the Supreme Court, my lords. And finally, IDCO has handed over 50% of that land to me, my lords.
Will allow impeding application.
Pass over.
Both two persons, already that land has been taken over, possession evicting, because he had taken for industries. And as per the allotment and also the agreement, it is followed by the agreement. As per the agreement, have to start the industry and commence production within 3 years. That he failed. That was given in 2009. Then Millard,
You are for that authority.
IDCO. So Millard, yes.
But where is the petitioner?
Only one pass over I am calling.
What was District 340? What Passover?
This time what Passover then?
I would have quoted Dr. for it.
Let us go to the next point. Next matter.
So we call tomorrow.
No, it will be in the list only.
Madam?
It will be in the list only. It's weekly list.
Okay.
My lords, the weekly list matters generally do not reach. So we are, a firm date can be given, my lords.
We are also trying.
Intervention can.
Yes, my lords, we understand.
Let us see.
Let the intervention be allowed, ma'am.
Let us see. Let us see. Yes.
Item 9, Writ Appeal 1469 of 2025.
Yes,
My lords, this matter may be taken up next week.
Next week, the request. Then you have not to that. Then you can pick it.
Item.
That's something we can Yeah.
Item 10, Writ Appeal 1527 of 2025.
Your lords, my lord. I have challenged the order dated 11/8/2025, passed by Honorable Single Judge at page 11. Only one aspect, my lord, that my disengagement order was quashed, but the Honorable Single Judge has directed not to reinstate me in service. Case is that, my lord, for Ayurvedic doctor under a scheme.
Now, what is the reason given by him?
No reason has been asked. You will also kindly see at page 14, my lord.
I'll read the operating portion.
Yes, I am placing my lord. 6.2, my lord, at page 13, paragraph. Since pursuant to the notice issued under Annex 1, petitioners were duly engaged by the order dated 10/12/2024. It is the view of the court that prior to cancelling the same, petitioners should have been issued with a show cause, and by following the principle of natural justice, such an order could have been passed. Since the same has not been followed, this court for the present while is inclined to quash the office order number 27/12/2024 so far as it relates to the petitioners. But with the observation that petitioners be given an opportunity to file their reply to show cause to be issued in the matter, this court directs the opposite party note 3 to issue a show cause notice within a period of 4 weeks hence, indicating the reason for such cancellation petitioner be given 2 weeks time to file the reply from the date of service to the so-called. Thereafter, opponent will be free to take his own decision in accordance with law within a period of 4 weeks.
What is wrong with this, sir?
No, this is right, my lord. However, it is observed that
You will not be entitled to reinstatement because we have said everything exception should be accomplished within time bound.
my lord, what is my humble submission is that
Once it is passed,
no, I was selected, my lord. I was selected. We have been given appointment. We continued in service.
How long?
For 12, 13, 14 days, my lord. 14 days.
Therefore, he has made that
Immediately,
order.
my lord, immediately, without any reason, you lost the kindly see that on what reason they have cancelled that engagement order at page 39.
Nothing absolutely in accordance with.
Let them reinstate in service, my lord, give an opportunity, my lord.
In this intra-court appeal seeks to call in question the learned single judge's order dated 11/8/2025 on the ground that once the WPC number 8205 of 2025 was allowed and the disengagement order was passed, the directions for automatic reinstatement ought to have been issued, whether inquiry is contemplated or not. First off. Next paragraph. Learned counsel appearing for the after service of notice, the official respondents are represented by Learned APA Mr. Behura, who opposes the petition appeal, making submission in justification of the impugned order and the reasons on which it has been constructed. First, having heard legal counsel from the parties and having perused the appeal papers, we decline indulgence in the matter in as much as about 2 weeks had elapsed after the appointment orders were issued to the appellant's hearing, and that the same came to be rescinded without giving an opportunity of hearing, which the learned single judge has found fault with. First, however, in the fitness of things, the learned single judge has directed the authorities to issue a show cause notice and permitted the appellants to show cause as to the proposed action. First off, he has also prescribed a specific timeline for accomplishing the entire task, and therefore, in his discretion, denied reinstatement, which otherwise in ordinary course would have followed. First of all, such a discretionary orders cannot be the subject matter of intra-court appeal and deeper examination. First of all. Next one, in the above circumstances, this writ appeal is disposed of, directing the authorities to comply with the learned single judge's order in letter and spirit in a time-bound way, as has been prescribed in para 6 of the impugned order.
Till today, they have not issued show cause.
Therefore, we have said that we have assumed they have not done.
Time limit may be my president.
Next paragraph. If the timelines are not complied with, then the authority shall reinstate the appellants in service, and thereafter they can proceed with the they can take up with the further proceedings in accordance with law. No person. Next.
Item 11, read appeal to
Yes.
the 19 of 2025.
I'm sorry, I was.
No, it's all right.
Item number
That IDCO.
IDCO.
President.
I am unable to get my file.
Well, that very well, no problem. But there was a gentle lady who was saying that impleading application should be allowed. Intervener application should be allowed.
Application, your lordship.
We can allow that application. Take out that. Which is that matter serial number? 8. An application in IN number so and so, supported by an affidavit, seeks intervention in the matter by the applicant as OP number, respondent number, As a respondent.
Respondent will be added
As a respondent.
7.
First one. Learned counsel appearing for the learned counsel appearing for the applicant submits that the applicant has already been is in the lawn. She has been allotted.
Yes.
Has been allotted.
Subsequent.
She has been subsequently allotted a part of the leasehold property, which is subject matter of the scrutiny in the appeal. First one. Next, having heard learned counsel for the parties and also learned counsel appearing for the applicant, the application is favored in as much as the applicant answers the description of proper party, if not necessary party, in the light of Apex Court decision in Rajia Begum versus Shahnaz Begum, AR 1958 SC so and so. First, the petition appellant is directed to array the applicant as a respondent number 7. Work with. Next.
I'll file my consolidated appeal memo.
Yes. No, you can amend it. Where is the consolidated? Just amend it by hand. That's all.
Only I pray that if they want to file any return before the next date,
call this matter after 2 weeks, and in the meanwhile, the newly added respondent may file his pleadings.
Item 11.
sorry,
No problem. Somebody mentioned about you. Yeah.
Right.
Item 11, rate appeal 2019 of 2025.
And take note tomorrow. Which one?
Right.
Item 11.
11 will also, I am filed to IA, one for intervention.
Yeah.
We have been participating in the Honorable Single Judge petition, Lordship, but we have not been made as party in this case. Lord.
You were party before the single judge?
No, my lords. We have participated through intervenor, Lordship. We have been heard, Lordship, in the Honorable Single Judge.
You were heard before
we are the party to the requisition, basing on which the no continuation motion was.
Panchayat matter.
Item 11.
Has been referred to the lordships in the third bench, that 24 to C, wherein the requisition along with the resolution.
Okay.
It is my lord's judgment.
Judgment is there, na? 3-judge bench decision.
That is decided. That's for if at all they are
That
making it tomorrow, it will be in the list.
You will be heard in the matter.
Yes, sir.
That's all. When the matter is taken, we will hear you. No order need to be put in for a-
Those pay order is there, Lordship. Pay Lordship matter may be taken up tomorrow, Lordship. What my
See, tomorrow also repeated, na? List will be repeated tomorrow.
Yes, list will be there tomorrow.
Item 12, rate appeal 3165 of
Item
2024.
12, I am the appellant, you know the appellant. Sick time or something, I am for the respondent.
In 12 you are not ready, Mr. Padi?
I am for the respondent.
On the 29th?
29?
At the request of Padi.
No, I am for the respondent, my lord, in item.
Yeah.
In item number 11, my lord, is sub-item.
11.
I have received the
1884.
Yes, ma'am.
Lordship. Respondent number 8, 10 and 17. And I'll file my Boklatram as well as.
3. Then so appears for OP numbers. Respondent number.
Respondent 8, 10 and 17.
8, 10,
17.
17.
17.
17.
17.
Okay. Register to print his name. Okay.
Item 13, rate appeal 151 of 2024.
My lord, here I am for respondent number 8.
But your friend is not here.
Yes, appellant counsel is not seen.
All right, let it be in the list. If he
Because
comes-
it may be taken.
That's what.
Are they?
We have a meeting today. Yeah.